My lord, I may be pardoned. Sorry. My lord, I may be pardoned to make a mention that the petitioner
Yes, please use the mic.
My lord, the petitioner is going to be evicted tomorrow, and the eviction notice has been issued earlier, and this may be taken tomorrow. Otherwise,
Eviction under which act?
On land acquisition. Land acquisition. Land acquisition matter, my lord.
And he is evicted. Means without compensation, what is it?
This may be taken tomorrow.
Restoration, my lord, because the order is preliminary like that with defect within 3 days. So by that not in order.
Pardon to make a mention, my lord. My lord, this writ application has been filed for a kind direction to the opposite parties to removal of public nuisance on the property of the petitioner. My lord, this matter may be listed.
Public nuisance.
Yes, my lord, my lord.
Why did you approach the competent authority? It's a division bench decision under section 133 CrPC. You can approve the appropriate authority.
My lord, we had made a representation to the
Representation, it's all right, but there is a have you gone through that decision of the Honorable Chief Justice and me, of course, has given that decision that any kind of such problem that can be addressed under 133, once it is brought to the notice what they are to do, every detail has been mentioned therein. All right, you give that and but go through that decision.
Yes,
Yes.
To mention, my lord, two criminal the present offense were in the inside the custody since 2013.
Please give it.
Yes, we clearly pattern on the Lordship, the compromise has been arrived between the petitioner and the opposite party bank. Lordship, I filed an IA for the same. Lordship, the writ petition number is 42806 of 2023. Lordship, I can be permitted to withdraw with liberty to approach this honorable court if
Item 40, kitne?
40
of the supplement. But it was adjourned yesterday to 27th of August 2024. Somebody made a mention yesterday. 48, 40. 40.
40.
It's a withdrawal of it.
Withdrawal.
This court.
But it is getting purposes honorable court if the cause.
Memo.
Lordship, I filed an IA for the same. I have annexed.
This court of IA is also the WPC is disposed of. All right, yes.
The one of the weekly list, my lord. We have challenged the auction notice which to be held on 23rd, my lord.
30?
31, my lord. The weekly list. Let the matter may be taken up before I.
Wait, when the matter reaches. Where are you mentioning?
Weekly list item.
Yes, wait.
Supplemental list, item number 1.
No, in this case, the petitioner is the loanee. Petitioner number 1 is the wife. Petitioner number 2 is the husband and also. So there are available loan, two number of loans, 24 lakhs. Another one was 66 lakhs or so. In between, they have repaid around 44 lakhs, but due to background and financial difficulties, they could not repay the amount for which the only residential building, the property, is being put to auction today also.
Yes, approach the appropriate forum.
Lordship, I am appearing, being instructed, I am appearing for the respondent today, Lordship. My lord, I am Satya Prakash Satpathy. I am appearing for LIC. My lord, the matter has already been once disposed of by your Lordship.
15/7/2024.
Previously, I was before this honorable court.
Yes, again you have filed another.
Course of hearing, the learned counsel for the petitioner, they have application. seeking liberty to file a fresh petition afresh since the cause of action for the present relief advanced in the interim application arisen after disposal of this relief. My lord, after this, I supplied the certified copy along with the representation. On the very same day, they rejected my application, for which I was bound to file an IA. My lord directed me that to file a better application.
It's all right. It is 13 for notice. Why will it interfere with?
No, my lord, my only sole play, lordship is, my lord, only I want some time, my lord, that's all. My lord, I don't want to. It's the fact that I have availed the loan and I have to repay the loan.
Instead of approaching this court, approach the appropriate forum, then you would have maybe have got the relief. Some cannot be entertained here because of the catena of decisions, and particularly when it has been repeatedly that no such application should be entertained. That alternative remedy of dispose of this.
Item 2.
Noblest.
This is land acquisition matter, my lord. My IA is at flag C for an interim order restraining the opposite party from entering into the case land, my lord. In the similar matters, my lords had switched to the opposite parties. My lord, what happened, my lord, on 26/7/2024, my lords are directed to obtain instruction in the matter. That my IA at page 9, that is the order. But inadvertently there is a error that running counsel for the petitioners was dictated in place of state. That has been also been corrected.
Yeah.
But taking advantage of this error, my lord, they have cut down 1200 trees from the petitioner's land on 37, my lord. The order was on 26/7, but they have cut down on 30th July, my lord. They have cut down 1200 trees, my lord. My document I have
What do you want now?
not to return the opposite party, not to enter into the suit land, my lord, and to take notice to the opposite parties. As my lords have already been issued notice to this in identical issues, my lord, in similar cases.
IA is 10745.
The notice has been issued to the respective opposite parties on 13/8, my lords. My lords had issued notice. But there is no interim order. But here, my lord, I pray for interim order as because they are going rule of law and my lords.
Land acquisition matter.
Yes, my lord. Without compensation, without any due notice to the opposite parties, they have petitioners. They have cut down the trees, my lord.
Say that there is no notice. Public notifications is there, and you must have also got the.
No, my lord. The notice, the communications in between them, I have been annexed in Annex 6 series between. But no notice to the petitioners to claim compensation, anything, etc.
No, there is a public notice, or you seek an individual notice?
No notice, my lord.
No. Public notice must have been there.
No, my lord. They are arising out of the land acquisition case of 3 of 2006. 3 of 2006, they notified for a private company as
which was subsequently for others.
Yes, my lord. Subsequently for the NALCO, my lord, in 2024.
This notification is there, as has been pointed out. Annexure 4 series of your petition is that notification, and
18, no, set of the 8.
Annexure 4 series is the previous land acquisition for the private company, my lord. That is not for the NALCO.
Again, my lord, page 32.
32.
That is my lord, for the self-same land which was notified in 2006. That was notified for the railway siding by the government of Odisha from this notified area of the 2006.
You come to 39, page 39. Your name is mentioned that.
That is for the land acquisition for the other railway siding of the government of Odisha. That is in view of the Act of 2013. The same area which was notified by the Annexure 1, that from that notified land matter, this has been by the railway authority, which clearly reveals that the 2000 according to 2013 Act, they have
notified from the notified area after 2006. I have given this document only because NALCO cannot do beyond these stipulations as in annex of
mentioned in
proceed.
this page 39,
Yes, my lord.
they have mentioned
Yes, my lord. That is for
what are
the
the plot, khata number, etc. They have mentioned that
yes, my lord. That has been mentioned from the
বিশেষ
yes,
বিবরণী
ma'am.
জনাইবে।
Yes, my lord. That has been paid.
Yes.
That has been paid, but that is different. But
What
NALCO is different.
No, whoever is there, you have already been paid.
No, my lord. I have not been paid.
Then what is
Just
this
take
notice?
just made a statement you have been paid. Now you are telling not paid.
That is paid for my lord. My lord, kindly turn to the notification 32 at page 32.
32.
That is notification done as per the 13 Act from this same notified area that was the
No, doesn't cover your land. The land for which you have come in the writ petition. Does it cover or not?
yes, also cover.
It is the self-same land.
Self-same land for the that has followed the 13 Act, my lord. That is the what in the for the NALCO they have followed the 2006 Act. That is my case. In 2024, that they have
Initially, your land was acquired for the purpose of NALCO.
no, my lord.
Then
That is for Kalinga coal mines.
Kalinga coal mines.
That has been abandoned for the Kalinga coal mines.
So the land was
Not acquired. So my lord, High annex of 4 cities you are acquired for the railway.
Yes.
But railway by following the Act of 2013 Act. But here NALCO, they have abandoned this, gone beyond this 13 Act, and they have followed the 2006 Act, my lord.
So why have you come in the writ? You have a provision.
Well, no notice, my lord, for the to claim as per the Annex of 4 series. They have not followed the provisions of Annex of 4 series, my lord.
Your prayer in the main writ petition, if
Yes,
we
ma'am.
come to this second prayer,
Yes, ma'am.
Yes.
why the petitioner shall not be provided due compensation by so and so for cutting down 300 teak trees
Yes, ma'am.
from the petition. That is your main prayer.
Yes, my lord.
So that is to be ultimately decided. You have, that means you have already
Our prayer also
just
have
listen to us.
Yes, ma'am.
That means what you have mentioned, that they have already cut down 300 teak trees.
After cutting down 300 trees,
You require compensation. That is your prayer.
yes, ma'am.
So now what is the question of them for cutting those trees, which has already been cut?
My lord, after
what is your interim application?
interim application, they have
cut the trees.
cut this rural.
Those trees have already been cut.
That has been cut after cutting up 300 trees. I filed this writ petition, my lord.
Yes.
Then my lord sir passed an order directing the State Council to obtain instruction letters
Yes. Then
on 26/7.
Yes.
But they have cut down that 1200 trees thereafter. In my IA, my lord, I have mentioned 1200 trees they have cut down after the order of this honorable court, my lord.
when they have cut down?
On 37, my lord. The order passed, my lord,
Till July.
yes, my lord. 30 July. But in 26/7, my lord directed to obtain instruction regarding the cutting down of 300 trees without due notice or compensation to the petitioners.
So if they have cut down these trees, that means you have already, those trees have been cut down.
Yes, my lord.
Then your option is now to amend.
My lord, let status quo be maintained, my lord, because they have
Now, if not your that to amend the writ petition and claim compensation for the rest of the trees, that means 900 more trees if they have already caught.
1200 more trees. 300.
All right, whatever. 1200.
ଥିଲେ ଆପଣ କହୁଛନ୍ତି 1200 କାଟିଦେଲେ ମାନେ 1200 କାଟିଦେଲେଣି।
On 37, they have cut down
1200 ର ଟ୍ରି ର ଆପଣ କମ୍ପେନସେସନ ପାଇଁ ଆଡିସନାଲ ପ୍ରେୟାର ବା ଆମେଣ୍ଡମେଣ୍ଟ କରିପାରିବେ ନା ନାହିଁ? ପିଟିସନରେ କରିପାରିବେ। ଏଇଟାକୁ କାହିଁ ଫାଇଲ କରିଛନ୍ତି? ଆଉ ସେଠି କଣ ଅଛି କିଛି କାଟିବା ପାଇଁ ଆଉ କିଛି ଅଛି?
The railway line by digging the land of the petitioner.
Mr. Counsel, your prayer is to
stop cutting, digging,
them for removal of the trees.
Removal, cutting, and digging of
what has already been done, that has been
and well, digging work is to be operated.
first per melon.
Yes.
Here melon.
Yes.
So there is a illegal case, CEO 2006.
Yes, that is already there.
That has already been argued.
Was the proceeding.
That has already been argued.
No,
In the
is it
court.
is which has been made in the interim application? Is it a correct statement that when his prayer is only for 300 trees compensation he was claiming, immediately after the issuance of notice you have bought and removed 1200 teak trees? That instruction you just take.
And my lord, still then status quo otherwise.
No, we do not know what is the position now. In that, in blanket way, status quo cannot be granted. Just take instruction.
My lord, in the similar cases, sir, my lord, sir, I have taken notice.
IN number 17.
My lord, similar matter, my lord.
175 of 2024. It will come next week. Let them obtain an instruction. This interim application has been filed with a prayer for a direction restraining the opposite party number 6 and 7 from entering to petitioner's land and oblique or restraining them to stop digging, oblique cutting, oblique removal of trees from the petitioner's case land under khata number. It appears that in the writ petition, the petitioner has petitioners have prayed inter alia for providing due compensation by the opposite parties number 3 to 7 for cutting down about 300 teak trees from the petitioner's land under khata number 151 in Mouja, Boloban. In the interim application, it has been stated that after the matter was taken off on 26/7/2024 by this court, the case was adjourned to 30th August 2024, and the London Council for the State asked to obtain instruction in the matter,
With regards to the illegal case.
especially all such facts relating to the land acquisition case number 3 of 2006. However, on 37/2024, the opposite party number 6 and 7 removed oblique uprooted about 12 from the petitioner's land in spite of the protest of the petitioner. The London Council for the State has received the copy of the interim application and seeks some time to obtain instruction in that respect. Put up this matter in the week commencing from 27th August 2024.
My lord,
A free copy of the order handed over to the London Council for the State. Yes.
in identical matters, that has been posted to 17/9, my lord, by issuing notice to the.
That is why we are taking up this matter on 27/8/2024.
Yes,
Next week it is just today. Yes, free copy today. Yes, next question.
Pardon me, Lord. Item number 1. I pray 2 days time to approach the appropriate forum.
No question. You can go today also if I can approach. There is no.
Today the
Yes. Sorry. Yes. Next.
Item
Okay, withdrawal. It is accepted, disposed of as withdrawn. Yes.
Item 4.
Please.
Yeah.
This is the case Hasmal Lease for renewal. And this is the 8th visit to this Honorable Court. And I'll just not in 1 minute, I can give a resume of what has happened, and thereafter I'll propose one viable aspect.
What is the chart for the? You said that this is the 8th visit.
Yes.
So we want to stop further visit to this court.
Well, exactly.
So
Exactly.
give
No,
that.
I'm just there for 1 minute.
You give that what has happened previously.
Sir, in 1 minute I'll say that.
Yeah.
The leasehold land to Kasba lease, the petitioner. Thereafter, on expiration of the there are 2 plots of land. We are concerned with a smaller plot of land. A bigger chunk of land has been settled, already settled.
Where is the land in question?
It is in Puri, Malad. And then, Malad, when the lease expired in 1976, after the expiration of the lease, I applied for renewal.
No, you applied for renewal in which year? In 1993?
No.
Since 76, it remained like that.
There is an admission by the
government.
No. Admission I can show. I'm not going to the records.
All right, we'll go.
By an admission by the government, there is a renewal application was filed much prior to 1990. But anyway, Malad, when the collector told us to file it again, we filed it again in 93. Malad is partly correct. And there was a renewal application pending, Malad. When nothing happened, I approached this Honorable Court. This Honorable Court gave a direction for disposal of the renewal application. When the renewal application was pending, then it came to light that there is a resumption case filed against my vendor who sold the property to me in 1962. Resumption case and the renewal are taken up together by the collector. And the resumption case was dismissed and renewal is dismissed and the resumption was allowed. Then I approached this Honorable Court. This Honorable Court quashes the order. Resumption order quashed and the renewal application remains pending. And then there was a direction to dispose within particular time.
Yeah.
Then nothing happened. Went on like this. Then finally the collector passes an order just reiterating the previous time, resuming the land and prayer for renewal. Then I approached this Honorable Court again. Then this Honorable Court directed me, of course not directed. In the order it's mentioned that you prefer revision under the provisions of the OGL. I prefer revision. Revision has been dismissed. I have come before Lordship. So it's a journey.
So now which order is under challenge?
Both the collector, the order of the collector and the Board of Revenue.
No, just a minute.
Now, what I propose now, Malad,
yes,
that if the governmental authorities and the petitioner, the citizen, and will find out a viable idea.
Where is that land situated? Puri, it's all right, but
Balukhand.
Here in BNR Hotel.
Okay. What is the area?
It is 0.9090 distance.
Oh.
Slightly less than 1 acre.
Hmm?
Slightly less than 1 acre of land.
So, I think the government machinery and the petitioner, they sit across the table. Yes, there has been illegality and irregularity because there has been lot of judgments of this Honorable Court without a single departure. And now, if the parties they can sit across the table and decide, then I have no object. What I am suggesting to my learned friend, if he agrees, fine, or else I will go ahead.
So,
if he agrees.
What is your suggestion? What is your
If
instruction?
that is possible, I will have to take instruction if that is possible across
Because
the
they may say that some more amount is to be given by
whatever would come out.
Yes.
That would be subject matter. Your Lordship may direct for pending, keeping the writ petition pending. And in the meantime, your Lordship may give us some time. I will take first of all instruction as to whether the government is agreeable for sitting together across the table. If they are agreeable, then your Lordship will pass appropriate orders accordingly.
So, all right, we'll pass that order, but let us fix a date so that on that day you can.
Yes, exactly.
Maybe may require, let us say, 2 weeks, 3 weeks, whatever it may be.
Yes, sir.
So, suggested date so that on that day we will come and we will take.
Milad, week commencing 9th of September?
No.
That will be good. Yes.
Time then. 9.
All right. After placing the case for some time, Mr. Sorisundar Das, land senior advocate, submits that if the party number, who is the opposite, but relevant opposite parties 2 and 3 or what?
Yes, it is the state.
Two opposite parties.
Tourism and revenue
Parties sit together for settlement. Then it is expected that the matter can be sorted out. In as much as this is the 9th journey of the petitioner to this court. And Action Government Advocate submits that he may be given some time to obtain instruction as to whether ready and willing to go for settlement with the petitioner or not. On consensus of both the parties, the matter will be stayed on 9th of September 2020. Instruction be obtained by the Land Council for the state.
Lord, item 5, I appear for the petitioner, Mahanadi Coalfields Limited. Writ petition number 39185, Lord.
Yesterday, your lordships have kept this matter just to find out whether the other matter, that means the matter in which notices have not gone, the second matter is connected to the first matter or not. So I think that's for the limited purpose. Both the matters were kept today.
Lord, may I just tell your lordships, Lord, this relates to coal acquisition matters. And in the sense, these are all matters relating to the acquisition for the Mahanadi. 1 minute. Madam, if you don't.
Order, we are supporting part of the order. They are challenging part of the order. We are challenging part.
I think this matter was in the weekly list.
Yes, your lordship.
And there will be mentioned that it is connected to this 369.
Yes.
Which was there.
Yes.
Which was there.
That is how
Lord,
it is.
Yes, and today your lordship precisely has called these both the matters just to satisfy whether both of them are connected or not.
Okay.
The same order is a challenge.
Let us see then they are in the both the application. 3918. What is the prayer? The prayer was dated 28/3/2023. The Claims Commission in civil case number so and so and claim case number so and so, annexure 8. That is the prayer. And what is the prayer in the next one?
Our prayer is really not to quash that, but what has not been granted in those order.
For escalation.
We will be granted. So there is a little background to this case.
You have come for the escalation.
Yes, the last order which the Supreme Court has passed in this matter has also told all the parties, all the people, that whatever residue matters also that you have, raise it before the High Court. So also there are additional prayers in this matter. It belongs to the same village. They have challenged the same village. This also, your lordships may just.
Annexure 2.
Lord, may I just say something, Lord, if your lordships permit me?
No. There is no dispute that these both these matters are connected to each other. That is the first thing we want to know.
No, Lord. Therefore, I just want to tell your lordships, the connection is each of these matters to be heard separately. If your lordships have a look at the order at page 250, which I have annexed, of the Honorable Supreme Court, Lord, these were matters which were monitored by the Honorable Supreme Court. At some stage, the Honorable Supreme Court felt that this matter should be relegated to the Honorable High Court. And therefore, Lord, these matters have come before your lordships. So all these matters could be heard on the same day, but they can be tagged together and heard as one matter. Each one will have to be heard separately.
Cross appeal. I'll give you an example, your lordship. The first prayer that we have made is to pass section to opposite party to add 36 escalation while arriving at the market value on 28/8/2015 for both land and structure. Now, your lordship, this is the prayer we had made before the Claims Commission. That is specifically denied, and to that extent, your lordships, I'll just show page number 82. That would be of WPC 3694/2020. 3694, second one.
On in the first one, I think the pleading is complete.
Yes, first one, pleading is complete. Your lordships could, my lord, hear it anytime at your lordship's convenience.
And for that matter.
And that's been relegated by the Honorable Supreme Court. There was an MA before the Supreme Court in those proceedings.
They can also complete the pleading because they are declining escalation. Claims Commission has not denied escalation. So I mean, can't be heard same village.
Okay, why don't you accept notice in this matter and so that it can be also disposed of?
But I have no issues. I have no issues. Your lordships may issue notice in that other matter. We'll accept it.
If you are appearing and we'll say that you have instruction to appear in this case and you'll file your appearance memo or wakalatnama, whatever.
Mr. Debraj will file.
Yes, all right.
So make your appearance in this case also. It can be, and if you want to file any counter affidavit, so we just will fix another date so that both the matters can be, or if any other connected matter is there with these two matters, you can give the list so that it can all come together and passing that order in this particular item. 39.
Lord, the only request is your lordship may not tag in the same date for hearing together.
It will come together itself. It will come together. So, had Mrs. Amir, senior advocate, appearing for the petition, requires the appearance. This petition has been filed by the petitioner, so and so. Inter alia with prayer to pass necessary direction to the opposite party toward 6% escalation while the arcade on 28/8/2015 for both land and issue note. So get a copy of the writ petition resolved on Deputy Solicitor General, Mr. Party, and the matter will listed. Give us a date so that. Affidavit. So
yeah. But then your lordship may give us 4 weeks to file counter affidavit. Complete the
so let it then come on 23rd September 2024.
Lordship, please. Lordship.
September 2020 on consensus. Counter affidavit, if any, be filed by the Monday.
Yes, a week.
Week commencing from
23rd.
So it will be there for the entire week. You may do any date if you so like. Counter affidavit in the meantime in advance, giving copies to the land. She is at liberty to file rejoinder affidavit to the counter if he so likes. So this should to be listed along with WPC number, so and so, and that date. That's it. Or
Obliged, but grateful.
keep the name space so that we can.
Weekly list item number 26.
My pre-malado kindly adjourn to one demand. For the even malado pass over for the day.
Pass over. You want it tomorrow?
Well,
oh. There are this okay connected matter. So on 22nd. 22nd. Yes.
Item 27.
Yeah. Next.
Item number 28. Item number 28 is the connected matter. Item number 32, madam. Both the petitioner are in similar footing, madam. And today in item number 32, I am filing the intervention application. And
for the petitioner. You are for the intervention.
Yes, madam. I am
for the petitioner. Have you solved a copy on the land and council for the petition?
Yes, madam. I have not solved, madam. Just now.
The land and council is not there.
Madam.
So,
madam, this matter may be tagged with another writ application pending at the instance of petitioner in both the cases, madam.
Let the land and council comes. We are just keeping as such. The moment he comes, you can take up the matter. You can hand over the copy.
Madam.
And other writ application is connected matter. It can also come and take up this matter. Okay, just wait. We are passing it over.
Nine.
Lord, I am appearing for the petitioner. Your land was acquired by the OP number 1 as per a notification pursuant to the Coal Bearing Areas Act 1957. However,
you have filed representations. You have filed representations before the authority annexure 4 series. Okay. Representation to be disposed of, but use a lot of further.
Item 30, my lords. My lords, this matter concerns acquisition of land under the Coal Bearing Areas Act 1957, my lords. Earlier, my lords, I have moved this Honorable High Court and an order was passed under Annexure 9 to dispose of the representation of the petition. My lords, thereafter, the authority has rejected my petition by Annexure. My lords, may kindly see Annexure 1 at running page 17 of the brief.
Why it has been rejected?
My lords, the operative portion of the order is at page 19.
Okay, come to that, let us see.
My lords.
Other side is the state.
My lords.
Have you given a copy of your writ petition?
My lords. Absolutely.
But no. There are so many opposite party, including
my
Union
lords.
of India is also
my lords.
Party and one of the coal fields. So, all right, see, let us see that.
My
it is in, you say it is page 19.
Page 19, my lords.
Okay.
My lords, if I may apprise your lordship of the factual crux of the dispute. My lords, here, the particular land that was acquired, it is a co-shared property, my lords, as inasmuch as it has not been partitioned, and there are various co-sharers of the property, my lords. I being one of them, my father is one of the legal heirs of that property, and I being the only legal heir of my father, the representation before the authority saying that there is no dispute as to apportionment or to the extent of right that I have over that over the amount of compensation. So my claim may be settled without any prejudice to the claims of the others, my lords. So, my lords, I filed a representation to that effect. The Honorable High Court directed to consider that representation, but while my lords Annexure 1, they have rejected my application, stating, my lords, may see the last para of page 90. There is no such provision and power conferred to the undersigned for disbursement of part compensation, where the ROR recorded jointly in the name of more than one person, and any one of the party did not ready to receive the compensation. Accordingly, in compliance to Section 17(2) of the CBA A&D Act 1957, the entire compensation is liable to be deposited before the tribunal.
Yes, that is correct position of law.
My lords.
So, you go for the reference of the matter to the court. Or if for the apportionment, you can go for a suit.
I leave
it is intra between the
parties. My lords, but my humble submission before your lordship is, with respect to my share of the property, there is no dispute as to apportionment because I am the sole legal heir of my father, my lords.
All right.
No, but that recorded in the names of others also. So they can have also their say. So that is exactly why,
my lords,
it has been. So,
and further, my lords, if I may,
that means you have now the alternative efficacious remedy available.
Yes,
to challenge this.
Approach the tribunal, my lords.
So, we are disposing of it accordingly.
Yes.
My lords, one small prayer, if I may.
Yes.
My lords, if are pleased to send it to the tribunal for my lords.
In writ petition, we can't give it.
No, my lords may give me liberty. My lords just may make it time bound.
That part.
My lords may just direct the tribunal to dispose it in a time bound.
You cannot direct the tribunal directly.
And time limit, what you are saying that you see notice has to be issued. So many. So
anyway, proper order will be passed with liberty. Next.
Item 31. Deeply obliged, my lords.
Yes. 31.
And the present petitioner challenges the option under Annexure 1, my lord.
Cell notice, right?
Eco Bank, my lord. Earlier, the present petitioner approached Honorable Court, my lord.
Same, you go to the appropriate forum.
My lord, last occasion, my lord, this Honorable Court directed to one-time settlement. In spite of complying the order of the Honorable Court, they have again issued a e-auction, my lord. My order has starting at page 22, my lord.
Appropriate forum for the alternative.
My auction is to be held on 23, my lord.
Maybe.
We have already approached them, my lord.
You have already approached?
Yes.
What is the number?
No. Yes, approach and the direction was already given for one.
No, he said already DRT approach. DRT approach କରିଛନ୍ତି ଆପଣ?
No, Eco Bank को approach करଛୁ referred to along with the order of the Honorable.
So next.
Item 32.
32.
It was similar to 28.
Yes.
Already in item number 32. 28 and 32 both are identical.
No, the land council wants to intervene and he has filed an intervention application. If you want to say something, go please and say so that it can be.
Subject to your lordship's appreciation, one sentence, my lord. Here, my innocuous prayer is, my application is pending before the Lorent Tahsildar Sadar Fatak from 22. Let it be disposed of in accordance with.
That is your prayer.
That is my prayer, my lord.
So why don't you participate there also?
They can participate. The mischievous attempt of the petitioner, I will disclose in the interpretation application. Series of order passed by this Honorable Court directing the petitioner to evict the land. Under OPLE Act, yes, my lord. There is no quarrel over.
You just come to the prayer.
My lord.
When I am filing the entire order sheet, the orders passed by this honorable and also the revenue authority.
Item number
Your
28.
Lordship may graciously please to admit the writ application issued on leasing coming up from the opposite parties to propose why Tahsildar Cutoff opposite party number 3 shall not be directed to take due and proper action on lease miscase 792 of 2022 filed by the petitioner on 25 February 2022.
That is still sub judice according.
The
Well,
petition
no,
number 21. This was
Madam, pursuant to the direction of this honorable court, madam, the appeal is proceeded by the initiated.
You appear also before so and so, and you will give a.
Madam, I have enclosed the entire order sheet, the entire orders of this honorable.
The petitioner has approved this court with 20 and
32.
to 32 also. Hello?
But this is item number 32.
Yes, yes.
The petitioner has approved this court with so and so prayer. The land council, Mr. So and so, has filed an interim petition for intervention.
Eviction orders.
In which item you have filed?
28. No, in 32. In 32.
32.
No, both the matters are similar.
Copy has been served. In view of the limited nature of prayers, so and so, since the matter is stated to be pending since 2022, we direct the Tahsildar Sadar Cutter, opposite party number 3, to decide the so and so case within a reasonable period, preferably within 3 months from the date of production of the certified copy of the order, and the intervener is at liberty to file appropriate petition.
Will be permitted to make a submission.
Yes, you approach there and telling
what happened, madam? Pursuant to the order of this honorable court, the appeal proceeding was initiated. He has participated in the appeal proceeding.
We have said, given you liberty to approve this so and so, and if he thinks
the eviction order has also been passed.
Intervention and
all right, then there is nothing to pass for the Tahsildar. If at all this order has been passed, the Tahsildar is only to go for execution of that.
Another writ petition is also pending, challenging the order of the collector. Another petition is also pending, madam.
So you bring it to the notice of the court.
Madam, suppress all the facts in the.
That means there is nothing to pass by this Tahsildar. Virtually the order has already been passed. Eviction is already passed.
Madam.
So already there is nothing to dispose of. That is how we have given a direction here to take all these pleas before the court. You can take.
Yes. You have granted you liberty, do the needful there. So yes, next.
33.
Registered yes.
Made peace minutes. As I purchase a land, if your lordship will kindly come to page 25. This is a sale deed for plot number 419.
Which for the other side? State.
State.
What is your prayer in this petition?
This is land acquisition is being done over my property without any notification. When
Annexure 5.
Yes.
You are challenging Annexure 5.
5 and the subsequent it came to my notice that my property is being sought to be acquired. Then I examined and found that this property was never notified. It was never notified. I have annexed the notification also.
Which is your property? The schedule of property have you given in the?
Yes. I have given my schedule of property at page 10.
Yes.
Page 10.
Yes.
Land situated at plot number 419, khata number 119 by 60.
So this is not included?
No, it is not.
Why are you apprehending that your property?
That is why I am showing annexure 5 minutes. 21st July, before annexure 5, your lordship will see annexure 4. WhatsApp re 21st July ko at 9:51 PM, a random number sends me this notice over WhatsApp. That is at page 44. My lord will see Praptesu Agarwala, Visa, Moja, Pipalkota, खाता नंबर 119 by 60, 119 by 69, plot number 419, 413. And what एत द्वारा आपन को अवगति निमंते जणाई दिया जाउची जे आसंता 22/7/2024 रे समय अपराह्न 4:30 जिलापालଙ୍କ सद्भावना
that period is already over. What happened on 22/7?
I went, I couldn't because I received the notice just the previous night. I couldn't go that day, but I visited the office. They said, they offered me a paltry amount. They said, if you don't want, we will take it. Go do whatever you can. And I have pleaded that. I have pleaded that in my petition.
No. When you approach this court?
I filed this petition on 9th of August.
9th of August.
This
So
is a
have you taken
2020.
that stand that you have gone there and
Yes, I have said so.
yes.
No, this notice is of 2020 or what?
No.
24.
Again, notification is of 2020.
Notification is of 2020.
Notification ne mo property ra na nahi.
No, it's a general notification, no?
Yes.
Covering the entire area.
Of the entire area, ko plot acquire hoji. Taro list achi, which is, my lord.
Yes. Does it include?
No.
Achha.
It doesn't. More dita prop, if I may kindly assist your lordships. Dita plot 413 jota e list re nahi. 419 ରୁ କେବଳ acquisition ହଉଛି 8 ଡେସିମିଲ. ପ୍ଲଟ ଟା ହଉଛି 72 ଡେସିମିଲ ର
Partly.
8 ଡେସିମିଲ. ବାକି 64 ଡେସିମିଲ ରୁ 16 ଡେସିମିଲ ମୁଁ କିଣିଛି by way of a permission from the collector. There is a collector permission at page 48 who has permitted that sale.
What happened on 22/7/2024? Where have you mentioned in your report?
Well, it's page 7. Para H.
Para?
H.
Yes.
It is further submitted the petitioner attended the meeting on 22/7, although on the short notice, and raised his objections orally. However, none of his objections were entertained, and he was told point blank by the OP number 1 that they shall anyhow acquire the said plots 413 and 419 and coerced the petitioner to accept a paltry sum of compensation without any regard to the fact that the petitioner has invested his hard-earned lifetime savings of a total of 17.6 lakhs into these properties.
So what happened then? You are at liberty if you suppose you are not satisfied with that compensation amount.
Well, there is no acquisition. I am not under acquisition.
No. If there is no acquisition, there is no compensation.
Precisely. But what they are saying is,
so in case your apprehension comes true,
yes,
and there is an acquisition, then you are not at loss. You can go to the court of law. There is a provision.
What I am saying is, this is being carried out. It has to, as your lordship said, there has to be a section 11 notification. Notification nahi, then why am I receiving bills? My humble submission is, why am I receiving bills? A notice under Annexure 5 saying that your property is being acquired.
But in what way you were prejudiced?
Because my property is being acquired.
Is yet to be acquired.
Yes.
Is yet to be acquired, number one. And if acquisition is there for any reason, then you will be compensated.
No,
not to the extent you were expecting.
Compensation is a stage that will come very subsequently.
Obviously. So, but you cannot stall the acquisition at this stage.
No. I am not stalling. I am saying my property shouldn't be touched because it is not notified.
All right. If that you say.
It be notified, I wouldn't have come before you.
Where is the notification?
That is what 45 was saying. 46.
46 plot number 413 nahi. We'll see serial number 6 list re achi kebol 419.
It may be that subsequently they might have added it by some.
No, I have inquired,
26 to 20.
and therefore to establish that if subsequently my humble submission is subsequently they add it also, then in that event, why would they issue that permission on page 48?
This has come on. This Annexure 6 is dated?
This
2020.
2020.
2020 they notified. Serial number 6, plot number 419, Rokava 720 decimal.
So you have nothing to say about 419?
419, I am saying, your lordship will kindly see that. Rokava 720 decimal.
Yes.
Adhigrahana Rokava
8 decimal, yes. Out of 72, only 8 decimal.
8 is being acquired. Boloka Roila 64. 64 mallards will come to page 48. It makes things absolutely clear. 9/5/2024, collector has given the permission property to me. In pursuance of subsection 4, section 11 of the Land Acquisition Act, transaction of the following scheduled land as per original trace map is hereby allowed. Mouja Pipalkota, Thana Booth, such and such. Malas, we'll see the table, column number 3, plot number 419. Total area 720, acquired area total 72 decimal.
This permission is subsequent to the notification.
Yes, Malas.
So which one will precede? Whether this permission will precede the notification or
no, this permission is granted because they themselves say कि हमें तो acquire करଛୁ 8 decimal सेथिपाई बाकी 64 decimal जो ताकू सेल करियार restrictions नहीं. No, I bow down to that doubt that is coming to your lordship's mind. May I assist your lordship?
Just take instruction on this matter. Kindly have a glance to Annexure 7.
7?
Yes.
That is this permission later.
Yes. Permission also transaction allowed for only 64 days. Not for total 72.
Exactly. I'm so grateful. My lords will kindly come to.
I will take instruction. Let's just take instruction about this aspect that his main thing is that in that particular plot that is not included in that
notification.
So whether there is any 2024. Maybe that we say that maybe that subsequent notification has come or something like that.
My lords will see page 30.
All right. We have to let him take instruction. We'll see that. The Land Council, the petitioner has filed this writ petition with prayer to quash the later dated sworn suit issued by the opposite party under Annexure 5. The main contention that has been raised by the Land Council is that the two plots which have been mentioned under Annexure 5 was not there in the note issued under Annexure 6.
26/2/20.
Dated 26/2/2020. Since there is time gap of more than 4 years between the notice dated 26/2/2020 and 15/7/2024. The Land Council for the state seeks some time to obtain instruction as to why that how these two plots which was not there in the notice dated so and so have come to be included within in Annexure 5. So take instructions and take up this matter next week.
Next
week. Yeah, 1 week. All right, it would be.
Let's have filed an IA Millets.
No question of stay.
Let's stay regarding these two properties.
Sorry, let it come.
They themselves have allowed billets under Annexure 7.
Say railway. Say use amount.
No, I'm not saying billets. I just insofar as these properties.
No.
Insofar as schedule of properties, let them be stayed.
All right.
Lordship is keeping.
Once it is stayed means
item 34. No, let's only these two properties.
No. We do not know that may be a necessity for them. Yes.
Well, let's say Lordship is keeping it.
That is would come on 2nd September 2020. Yes.
Months. Great.
Item 34.
Item 34 is similar to the photocopy I have given to
earlier.
Yes, my lord.
So instruction is to be taken.
I have given the photocopy of the
Which one?
And it is also
item number seta
that I have
supplementary achi.
Supplementary 2 row that is
similar
to this.
Similar
and
to
mileage have kept it to 27th August.
27th August. Yes.
Supplementary item number 2 review order. So it is to be tagged with that case. Yes, next.
Number 35.
And the petition that is his lands has been acquired by the opposite parties. For the compensation amount, as well as the compensation appointment has not been given to the concerned petitioner. So in this regard, the representation Annex 4 is still pending before the opposite party number 3.
The representation is there. Annex
Petition is Annexure 4. It was filed on 7/10/2020. Stated has been received. If any such representation is pending, it is to be disposed of within time.
Other two matters are same. Connected matters.
Which matters are same? Other two matters connected.
The time limit of this
Madam, my lord, in item 34, I am giving two other repetition numbers, madam. That will tag to that.
It has come on the board.
No.
And then how can we take it?
Wait. It will come tomorrow.
You will.
Okay. So these are this item number 35, the Tinta matter. It is to be disposed of. Disposed of representation. Yes, next.
Item 36. Item 37.
Mr. Katke has already appeared in this case. Mr. Katke has already appeared in this case. I don't...
In 36 and 37.
Yes.
In item 36 and 37.
36, 37. 37.
36, no one is present from the side of the petitioner.
Yes.
And
We are in 37 now only.
Yes.
Perhaps this 36 council is there.
Yeah, Mr. Yadav, you are there in 36.
Please unmute yourself.
Kindly unmute yourself.
No, we are not watching silent movie. Please unmute yourself.
So Yadav, kindly unmute yourself. We are not able to hear you. Yes.
My lord, this is the matter of land acquisition, wherein the petitioner prayed for issuance of a certiorari for calling all the records from the government, and it may be quashed. Thereafter, the petitioner also prayed for the writ of us, directing the respondent government to give the return to the land. Why? Because the land for which purpose was land acquisited, that the purpose was not served. That is Annexure 7, my lord. Annexure 7, the government has been abolished the commercial check gates. The land is remained unused. Moreover, the petitioner did not receive the compensation, as well as the government also has not paid the compensation. Therefore, the Annexure 8 is, my lord, it is representation, page number 35 to 41, my lord. Detailed representation has been submitted, quoting that the section under section 101 of the right to fair compensation and transferation in Land Acquisition Resettlement Act, my lord. Because this is the only land for the petitioners, their lives have been depending upon the agriculture. Moreover, the lands are Garbari, because the land situated east of a mini town of Girsala, my lord. That is the mini town of Girsala. The land has been very valuable. The benchmark valuation slip issued by the sub-registrar of Chekite has been filed Annexure 11, my lord. The government did not fix the compensation. Moreover, the land has been not used for which purpose the land has been acquisited by the government. So the petitioner therefore prays that the land may be returned to the petitioner on the ground on the ground that the land for which purpose was land acquisited, which that is not used, my lord, for the last so many years.
Yes.
So now you stop. Please answer our query. You submitted a representation by the Annexure 8.
My lord.
You got your reply on by the Annexure 9.
My lord.
See for page number 43 what the additional district magistrate collector has mentioned therein.
Page number 43. Now the petitioner by this representation seeking relief under section 101, 107, 108 and 13 of the related act, which is not all the applicable to the petitioner's case as this earlier project work. That is not correct, my lord. The land, the act itself under section 101 is clear, my lord. Under 101, moreover, under section 19 also, the government may acquire land for the public purpose. But what purpose the land acquisited, it is certainly it must be used. If it is not used, the land is returnable to the owner. Moreover, the government has no change the any status of the land. Under section 19, my lord, I may be allowed to read out. No change of purpose to be allowed. No change from the purpose or related purpose of which the land is originally sought to be acquired shall be allowed, provided that if the land acquired rendered unuseful for the purpose for which it was acquired due to the fundamental change because of any unforeseen circumstances, then the appropriate government may use such land for any other public purpose. But in this matter, my lord, the dispute between the petitioner and the government is so long time because the land is situated a Garbari land, the annexure, my lord, adjacent lands have been valued by the government. The annexure 45, my lord, annexure 11, page 45, my lord. The adjacent land is an acre rate is 55 lakhs, my lord. But they are saying the government fixed the rate of the land very small. Therefore, the compensation has not received by the petitioner and the dispute is pending till today and the land is not used for the what purpose because of the government policy. The government policy has been abolished the commercial check gates due to GST, my lord.
Receive your compensation. What is your prayer? You want your compensation amount or you want that land?
Land, my lord.
Yes.
Because the land is very valuable. Government knows no. If it is purpose, if it is necessary for the public purpose of the government, the petitioner no objection. If the government pays the land as well as the market value fixed by the government to the adjacent lands. But these lands are not required to the government. Therefore, the land may be returned to the petitioner. The direction of this honorable court, the direction of the honorable court, the petitioners are praying for that order, my lord.
Have you not received any? Have you not received any compensation for the acquisition of your land?
No, my lord. No, I did not receive any compensation.
How is that they say that it is already completed since 2012?
Section 2 notification was made in the year 2007.
My lord, let them come with the. Therefore, we prayed for before this honorable court calling all the records before the honorable.
We do not want all the records. We just want that if your lands have been acquired by the government for certain purpose, whether you have been compensated at all or not, what you just submitted that you have not even got a single pie for that. So,
my lord,
this Mr.
It is for the expansion of National Highway.
Yes.
What was the transfer of the Girishwala gate?
No, it's all right. Whether any compensation has been because he's making a statement that no compensation has been paid. On the face of it, very difficult to accept, but whatever it may be. So, who is to answer all these things? Whether you are the main opposite parties, all the opposite
Yes,
parties
it's
are
the
the
government.
state.
He will take care.
So you take instruction on this aspect.
I'll take instruction. I'll take instruction.
It was acquired in which year, Mr. Counsel?
My lord, since my lord,
2007.
moreover,
2007.
this is a general notice. Particular notice has been not issued by the government. However,
notification is there in 23/3/2007 in
Plus, earlier also two other writ petitions have been filed by the petitioner.
yes. What happened to that writ petition?
There was in the first one direction has been filed this honorable court has passed a direction to dispose of the representation.
Petition disposed of, and that is ultimately the collector has disposed of. We pointed out to that also. But
Yes.
not concerned with that. We are concerned that whether he has been
Received
paid.
yes. Received the compensation.
Right, that is.
Let me take instruction.
my lord, one submission, my lord. The writ petition number Annexure 6, my lord. The writ petition has been dismissed honorable court on dated 19 December 2017, my lord. But prior to that, 28 March 2007, the government policy was that the commercial check gate was abolished. That information was not provided by the opposite or the government, appropriate government to this honorable court.
There was a direction by this court in the writ petition, which is the order has been annexed as Annexure 6. Relevant
Open
page
to
number.
the petitioner to receive the compensation. Open there is a court, my lord, court direction. The petitioner is open to approach the appropriate government to receive the compensation, but the petitioner did not approach. However, it is the burden of the government when the commercial gate is the commercial check gate was abolished. The information has to be provided at the time of hearing of the writ petition before the honorable court. That is did not do by the government, my lord.
Concerned with you or whether you have received the compensation or not. That is the main thing we are whether
I did not receive compensation, my lord.
The land and counsel for the petitioner submitted that even though the petitioner's land has been acquired on the basis of the notification dated 23rd
March 2007.
23rd March 2007, issued by the opposite party. For construction and transfer of commercial check gate on the old NH5, now it is NH16 of the National Highway, but till date he has not received any compensation from the government. However,
because the compensation was not adequate for the market value, my lord.
We want a reclamation. We can't help it here in read.
The land counsel for the petitioner placed what is that order disposing of the representation that it seems that the collector
on
17/11/2018 disposed of the representation of the petitioner in pursuance order passed by this court in WPC number 4082. What is that order? Honorable Court has passed the order on 19/12/2017.
408 to 2011.
2011.
19/12/2017 in WPC number 4082 of 2011. That is annexures the land council for the takes some time to obtain instruction as to whether the petitioner has received any compensation from the concerned authority for acquisition of his land, and for an adjournment put of this matter in week commencing 2nd September. Let it come, Mr. Katkia.
Yes, may be permitted to place one paragraph at page 29, my lords.
29.
Yes.
Yeah.
Yes, Learned Council for the State with the private submits. The award has been passed on 18th June 2009 in presence of the petitioner and other co-owners. It is further submitted that as the landowners, including the petitioner, they will come forward to receive the compensation amount awarded in respect of the acquired land, the authority after waiting has been forced to deposit the same in the district treasury, Chhatrapur, by challan number so-and-so dated 30th October 2012. It is further submitted that in absence of any dispute with regard to the quantum of the compensation amount assessed or the apportionment thereof, or with regard to the entitlement to the compensation acquisition officer, there is no scope for referring any such dispute to the competent civil court. Therefore, the acquisition officer could not have deposited the awarded compensation amount before the civil court. Considering the submissions made, we do not find any merit in the repetition, which accordingly dismissed. It is open for the petitioner to approve the land acquisition officer to receive the compensation and also for payment of interest from the date of award.
So, question is that there is a very clear order on that he has to approve land acquisition officer to receive the compensation.
Yes, yes.
He has we want to know that whether he has received the compensation. If it is his fault, he has not. You just give the instruction whether he has received compensation or not. That much of it. 2nd September 2020.
Item 37.
But made me yours.
Yeah.
But the petitioner happens to be a lessee in respect of a piece of land which was allotted in 2006 hotel. It's a group of hotels actually, Indian Management of Hotel Group. This Route Corporation Limited is one of the out of one of the said group. But here the petitioner has invested more than 2.5 crores for development of the land and has raised foundation even. But due to recession and other difficulties, the building could not be completed. But if your lordship looks, a notice was issued at page 46, annexure 5. They say that you have not completed the hotel as it was given to you. Therefore, it is going to be resumed in section 3B of the OGLS Act. A reply has been given as page 47, annexure 6. We have indicated question of resumption doesn't arise because 3B has got no application to the instant case. We have also indicated in page 46, we have already spent 2.51 crores and construction has been made, may not be complete. So it cannot be said it has not been utilized for the purpose it has been utilized. Then without any hearing, they have passed an order at page 50, annexure 7. Kindly see an order in fact. At page 50, in exercise the power vested on 3B, the following scheduled government land measuring 1 acre leased out in favor of road corporation is hereby resumed. So no reason, nothing has been given. I filed a writ application before this Honorable Court. In the writ application, the Honorable Court directed that you better approach the alternative remedy that is available by filing an appeal. So liberty has been granted to pursue the matter for the appropriate authority. I filed an appeal. If you lordship turn to page 54,
Yes.
the appeal has been admitted, notice has been issued. Page 10, action 10 at page 55, the last paragraph. In view of the above observation, I have filed that the appellant is hereby disposed of with a direction to both parties to maintain status quo over the suit line till submission, placing of LCR otherwise comment before this group. Then if you also kindly turn the construction that was made at the time when the notice was received, page 56, Annex 11. Well, recently, I've indicated in paragraphs 16, 17, and 18 that some other persons, they are raising construction about the same. It's the tourism department of government who have now raised the construction without my knowledge, without informing me, and it has not been leased out to anybody else. The matter is pending for RTC. Pain. All those constructions have been made in the meantime. So I immediately approached the RTC.
No, these constructions have been taken up by the government.
It's government land.
The government land, but it was leased out in your favor.
Yes.
Because you did not bring the construction within the time mentioned in the lease.
No, lease it doesn't specify any time.
All right. The purpose for which you had taken the lease is not the question. You could not raise the construction.
Right.
So, against that assumption, you have got the matter appealed in proper forum and status quo order has been passed. But you say that these constructions have been taken by whom? So many constructions.
Tourism department.
But not today. This construction must have come long before.
No, sir.
See, the huge constructions have come up.
Construction.
57.
Sir,
Is it on your land?
This is the land.
This is the very land which you are showing.
Yes, yes, my lord. Sir, I have shown the.
What happened? You approached the
RTC.
RTC. What happened?
Sir, RTC is absent. He has been transferred as a. He is in the election duty. Thereafter, no RTC has been appointed. Nobody is there manning the chair. My application is there, annexure 13. Clerkship looks at page 70.
So your main grievance is that that status quo order has not been implemented. That is how this. Yes, sir.
The government council was present.
But
yes,
nobody there in the RDC.
How can it be? Somebody must be in charge.
What is your instruction, Mr. Katia? This application.
But I don't have any instruction just now.
This annex is sub judice before this one. So, but
yes,
submitted.
if any application has been filed by, by the petitioner before the RDC.
That is annexure 13.
Yes, annexure 13.
Yes, he said that no one is there to.
And an order is already passed under annexure 10 by the RDC.
It is just to implement that order because there has been construction flouting the order that status quo order. That is exactly his case. So take instruction whether there is anyone. We can take up this matter tomorrow itself. If there is anyone to consider this application which has been filed under annexure 13 or not.
No, not again tomorrow. May humbly Monday.
No, somebody is in charge of RDC who is to take up the matter.
Pattapura RDC office, you can take that instruction. What is there?
Whether the RDC Southern Division or who is in charge of this?
What is Central Division?
Central Government Pattapura RDC.
I am taking instructions.
RDC has been deputed somewhere else and he is not there. It doesn't sound.
No, he has been deputed, but whether somebody is there to look in petition to consider it or not. Otherwise,
Sri R. Santa Gopalan.
Yes, application has been filed on 13th August 2024.
Yes.
Right. That is so.
Immediately after coming to know about the construction, we filed.
That is what?
Yes. And thereafter, I think no further order has been passed by the RDC.
Speaking of this matter, tomorrow, Mr. instruction, whether there's one to deal with this application or not. That's all we want to come. Take down. Mr. S.K. and senior advocate for the petitioner. Prayer has been made by the petitioner inter alia for a grant of temporary injunction from raising construction over the suit disposal of the OGLS appeal number 5 of 2023 pending before the Court of Revenue Divisional Commission Central Division, Cuttack. Mr. Mishra pointed out the order dated 2020 22 2024 passed by the ADC under Annex 15, wherein in the operative portion it has been mentioned that the IA filed by the appellant bracketly is disposed of with a direction to both the parties to maintain status quo over the suit land till submission of the placing of the LCR of the PWC. What is PWC? Paro is coming before the court. The Land Council showed the photographs under Annex 12 submits that in spite of such status quo order, construction work being carried out, and therefore he has filed an application Annex 13 on what is the date of application? 13/8/2024 for implementing the status quo order dated 22/3/2024, but there is no one. No one has been selected as RDC to deal with such application, and in support of such contention, the Land Council has produced later dated sworn show of the Principal Secretary, which is taken on record, but Kerala and additional government advocates it's time till tomorrow to ascertain whether there is any competent authority available to deal with the application under Annex 13 or not. Put up this matter tomorrow. Yes, pre-copy of the order be handed over to that council. Yes.
Item 38.
None. Next.
Item 39.
Next.
Item 42.
Item 40.
41.
40 has already been disposed of. He has withdrawn the writ petition.
My lord, our power is there, my lord.
How we will not just note your presence.
Our presence.
I have an item number 41, your lordship.
Yes.
It has been. You want your name to
Name will be reflected, my lord.
40 day. Kahana
Mr. S.K.Sahoo senior advocate and Ekin Naik.
put a sleep related. Item 40 day नाटा include कर देवे. she first hour mention कर देवे.
41, your lordship, I mean there.
Yes, it is 41. It is adjourned to 27th August 2024.
Obligations.
Nobody is there. On the next
Joseph.
Yes, you are there.
Yes,
Yes, ma'am.
yes.
Petitioner's land was taken over without taking recourse to provisions of the Land Use Act. And Lordship see
Reading complete.
my lord, almost everything is completed.
So they have accepted your stand that it has been acquired without.
The counter affidavit filed by the
What is
Union
the stand?
You also see next
Item 42.
Yes, Yogeshwar Mayor versus Union of India. Pardon?
That Johar Navodaya Vidyalaya might have that matter. There is a land which was occupied by this Navodaya Vidyalaya Samiti and built up a school there. And private party claiming that I have my property has been grabbed by the Navodaya Vidyalaya Samiti and I am liable to take compensation. But in this case, there is a suit pending before the court below for education, who is the rightful owner and basing on which this suit is going on.
So, what is that suit number? Have you mentioned in your counter affidavit?
Yes, yes, it was additional affidavit was filed. I'm sorry, my lord, this and counsel
of the counter which filed by
who has filed the counter affidavit? By the opposite.
Since long. Oh, yes.
Prashad is the opposite party number 3.
Yes.
Court suggested the earlier occasion the court suggested us to obtain instruction if there is a more land which was given by possession by the government, but it is a more land. If they are liable to get compensation, then you pay the compensation that may be settled between the parties. In that context, we wrote a letter, we have not received any instruction. Admittedly, what I came to know that there's some more land is there.
No, suppose that particular land, whether it is of the petitioner or it is of somebody else.
Not it will be identified by the defined by the civil court only.
That is exactly what we want to know, that whether that civil suit is pending or not, and whether he has been added as a party. And
my knowledge is concerned is pending, my lord.
What is your instruction?
No suit is pending.
Mr. Padi, can you give the number of that suit and which court it is pending?
My lord, let's keep it to some other day. I will get this instruction and all this I will appraise.
Court name.
You see, Annexure 5, page 32 is the demarcation report pursuant to direction of decisional court.
Is all right, but if it's a disputed question of fact,
civil dispute is going on, what I came to know, yes.
In session over the matter and the very same land.
You see, may I bring you only one thing? You see, page 39, para 11 the counter filed by Union of India. Page 39, para 11. May I place it, my lord?
39.
Yes. That replied to para amendment made in para 5. The writ petition humbly submitted that though the assertion of this para cannot be done by the present opposite party institution, it is the duty of the state authority to settle the dispute arising out of transfer of land and to compensate the petitioner if any land is occupied by institution at their behalf. Because the land which is in occupation of the institution was provided by the state authority after duly demarcated, thereafter the position was handed over. So the institution has not deliberately or willfully occupied any land of the petitioner, for which if the compensation against the land which is in occupation of the opposite party institution, the same may be is to be paid by the state government.
No, this is filed by opposite party number 3, that principal of that.
Principal of the college.
So there is.
So what the Annexure 9 is that suit? Annexure 9, title suit 5 of 2016 or what? Civil Judge Senior Division Patnagarh?
Yes, that is. Yes, rightly, my lord.
Annexure 9.
Annexure 9.
Annexure 9. Copy of the.
Hon'Ble Meher versus Union of India, Collector, Principal Navodaya Vidyalaya. Here it is different, but of course, probably that is the problem. That is what he is saying. Advocate for the defendants is present. No legal heir of the deceased plaintiff, Hon'Ble Meher, is substituted. So there is this suit is pending. So, what is the plot number? What is your schedule of plot?
Yes, see. That will clarify also. See, page.
Plot number?
Yes, I'm coming to that. Page 14, my lord. I am the recorded tenant. Page 14.
No, plot number?
Plot number 197.
It is there. Subject matter of the
Then plot number 195.
197.
Plot number 194.
195, 197 is there.
194.
194 ta nahi, but
197 is there. 28 decimal. Ananya Munda.
Ananya Munda. Nature Lekhaichi of property. Please come to that Annexure 9, which is there in the rejoinder affidavit. You have filed the rejoinder, na?
Yes.
Yes, come to your Annexure 9.
Annexure 4, page 27.
No, Annexure 9. Annexure 8 is also there, another Hon'Ble Meher.
Keep it there. Next week.
Another 5 of 2001.
It is your document.
Yes.
You also annexed those about what Mr. Padi is making the submission. At least this document indicates that there is a civil suit, and the same land is involved in that particular suit. The schedule of property, that land has been mentioned. So,
may you skip it next week? Next week can be discussed.
All right, Mr. S.K. Joshi, Land Counsel appearing for the petitioner. When a submission was made on behalf of Mr. Padi and Deputy Solicitor General,
the petitioner's mother is a party there.
That
Mother
the property in respect of which the petitioner is claiming relief is
subject matter of the suit.
For that matter, a civil suit is pending in the court of Civil Judge Senior Division Patnagarh. In TS number 5 of 2001. And copy of the order passed in the said suit has been annexed as Annexure 9 to the rejoinder affidavit filed by the petitioner to the counter filed by the opposite party number 3. The Land Counsel for the petitioner took some time to obtain instruction. This Dhandai Meher is your father?
No.
No, man.
Mahadev Meher is a party.
His father is Mahadev Meher.
Mahadev Meher is a party.
Mahadev Meher is a party.
Yes.
That is a party.
Yes.
Okay. And the father of the petitioner is a party, is the defendant number 5 in that civil suit.
Non-family property. By the
That is why
at
it has
instance
been,
of the petitioner's great grandfather, suit was filed.
that is why.
Partition was made, and the land which was taken over by the opposite party is fell to the share of the petitioner. Fell into the share of the petitioner.
And it is to come. You want it next week? Yes, it is to come along with this WPC number 1855070. All right.
My lord, 1850 is already in the list, my lord.
Yes,
Yes,
it's just
yes.
the matter. We passed this order in 17135 of 2000.
Yes.
We recorded your submission and we just
Yes.
posting it next week, and it is to come with that matter which is already there in the list. Okay, yes.
My lord.
Next week,
Next week you said.
Week after coming. Should have instruction on the YouTube.
All right, 2nd of September 2024. Yeah.
Can it be on 3rd of September? The 2nd may not occur.
Weekly list, Mr. Padi, you can do it.
Yes. Sorry. Yes. I got it. Yeah.
Item 43.
We are just coming within 2 minutes.
Item 43.
In this writ appeal, my lord, I challenge the order passed by the Honorable Single Judge. In Annexure 6, it runs from page 77. My lord, the case of the petitioner was that he applied in pursuance to the advertisement issued. 1 at page 37. The opposite parties, they advertised for the your Russian candidate at page 37, 40 posts of management training. These from 30 posts, my lords, 20 was reserved for unreserved persons and 20 for the reserved people. This 20 has been distributed. Scheduled caste 6, scheduled tribe 3, OBC 11. I am a scheduled caste candidate. I applied for the my application was processed. It was found to be in order. I was asked to appear in the written test. I qualified the written test. Thereafter, I was asked to appear for the viva voce test. I appeared the viva voce test. And thereafter, my lord, a selection list was published. In the selection list, since my name did not appear, I made an inquiry and I am told that since your name is not reflected in the merit list, that is why your name is not indicated in the select list. On inquiry, my lords, I asked for Information Act that the reservation made for the 6 scheduled caste candidate posts were not filled up. Their vacancies are there. And though I justified what they did, my lord, they said that while in the counter they say the assessment was written test 150 marks. Then, my lords, the personality test 20 marks and the viva voce was 30 marks. That is how 200 marks has been distributed. Did a cut-off mark, so that was not, it was not disclosed or not intimated. For the reserve categories, the cut-off mark they say 40%. And for general candidate, the cut-off mark was 50%. According to their counter, my lords, what they explained, you are to secure 40% marks being a scheduled caste candidate in all stages of selections. Written test 40 marks, viva voce test 40 marks, and also the other test, that is, you must have to have it 40 marks. If you don't get 40%, you cannot be selected. That is what they said in the guide applied to me. Under the information, they said that the cut-off mark of 40% of general candidate, 50%, and scheduled reserve 40% was throughout maintained. I applied for the right information to know what the persons who have been selected, what is the percentage mark they have got it. Ultimately, my lord, I could come to know. Your lordship can have a look to, I have annexed that at annexure. At page 48. What? Then GD mark, that is, they say that personal test and interview mark. Your lordship can see if the 50% that was never intimated earlier that these are the persons of mark that are going to have it assessed. However, let us have it, sir, my lord, that they have assessed that. Then in that event, my lord, for the general candidates, 50% of the cut-off mark. The mark sheet indicated that this was never maintained for the general candidates, so also for the all the reserve candidates. As a result of which, when I applied, an interim order was passed that if a post of scheduled caste vacancy is available, that should not be filled up without the leave of the court. After the writ application was disposed of, when I filed the writ appeal, this honorable court was just pleased to pass an order in the writ appeal that if the post is lying vacant, that post is to be allowed to continue. Well, that is the process when the entire, my lords, I will be placing my entire document, that the process of selection was not in pursuance to the selection they are supposed to do that. But unfortunately, was dismissed on the ground that I have not made persons who are the opposite parties who has got the lesser mark than me. My lord, my specific case was that I am a scheduled caste person. Scheduled caste vacancies 6 are meant for the reservation for them. All the scheduled caste posts have not been filled up, vacancies are there. And ultimately, my lord, a post has been kept reserved by the order of this honorable court. When a post has been kept reserved and I have not alleged or made any allegation about any other persons, the question of making the opposite to anybody as a party, or since I have not challenged anybody's appointment, nobody is going to be affected. In that view of matter, without considering
so out
the
of
case,
that SC quota,
yes,
you said that 6 were there, and that has not yet been filled up.
Yes, my lord. Okay. Vacancies are still there.
What they say in the counter affidavit?
My lord, they are quite silent about that.
Okay.
I have indicated in my reply, I filed a miscase. To miscase, they filed a reply. They did not disclose that. They only say in the miscase, reply to my miscase, we have adopted action. You must have to have it 40%.
But Mr. Ratha, suppose, let us say, the state would make a submission on taking instruction. We are telling that all those 6 posts are filled up. Let us say, for example.
Yes.
So then it would be, it would have been necessary to include those persons or not as parties. Because they are likely to be affected.
Yes, my lord. If they say, because they have not said so.
No, I just.
Yes, my lord has given a hypothetical proposition. Yes. In the event, my lord, the post after the interim order, first question is when the posts are filled up.
No, that is of course.
If the posts are not filled up past, and they have filled up the post subsequently, my lords, I need not make anybody party.
Okay.
But if the post has been filled up by the time I filed the writ application, definitely, my lords, the question put that is correct. Because somebody is going to be affected.
Then the order of the Honorable and single judge is also correct.
In the event, well, there must be a predict to that extent. There must be document to justify. Yes, posts have been filled up. You did not make them party. Who is going to be affected?
So, what is your instruction, Mr.
Because we have nothing to say because the company
state has. My lord should remember the little history of this case. It was taken. The party did not contest even there.
No, subsequently there to no vacancy has been advertised.
No, my lord. Subsequently, no vacancy.
This was an advertisement for.
Because my lord, vacancy they have filled of 34.
So the vacancy was in 2008.
Yes, ma'am.
And till date there is no further.
No, there is not further.
So who is to answer it is opposite.
Nilachal
Ispat.
And my lords, your lordship have taken that day that before the other division bench, my lord, the direction was that the lawyer who was to conduct the case in the previous, before the writ court, I am to serve. I served a copy. Thereafter, he did not respond. Yes, my lords. And thereafter, your lordship have passed that order, since that the notice is sufficient in the writ appeal. Nobody turned up. And state has nothing to do, my lord. Here
no, state has nothing to do, but the company has also nothing to do. All right. So now the notice is served.
And that is sufficient, my lord.
Well, the counsel is reflected in the cause list, but none appears, Mr. Missouri from some states.
Your lordship has put me a question, which was not a question before the honorable single judge. Because the question was, if the post would have, whether vacancy is there or not, whether post has been filled up, that was, because that is nobody's case there. My specific case was 40 was the advertised post, 34 has been filled up, and your lordship have protected by giving a direction that if a post of scheduled caste post is not filled up, not to be filled up, My specific case is all the posts I have not filled up, so the scheduled caste is concerned. My lord, no response has come from the opposite parties.
Where have you stated that all those posts have not been filled up? That scheduled caste.
My lord.
So 6 posts were reserved, which has not been filled up.
Yes,
Where is
Where
that?
is that Adjournment?
Adjournment, yes, ma'am.
That is probably in page 12.
Yes, my lord, sir. I made a...
The post belonging to SC had not been filled up as a result of...
SC, ma'am.
This is read appeal.
Read appeal.
Your lordship can have it, have a chronological dates of event.
As a result of which there will be one post available.
My lord, sir. Assistant.
No, if not at all, so not a single post is filled up in SC. There are 6 posts.
My lord, ST post, I'm not concerned.
No, scheduled caste.
Scheduled caste. My lord, scheduled caste post, your lordship can see the list. They say, yeah, that list, my lord, will get it at page. They have given, they have only 8% for electrical wing they have given.
Another thing we just want to know from you. Let us say in the SC category, there are 6 posts.
Yes, ma'am.
3 has been filled up. Hypothetical. 3 are lying vacant. And you have not admittedly included those 3 persons as party. Suppose in case we allow your writ petition and give you the relief, your placement may be above those 3 persons also. Maybe you may go to number 1, they may come to 2, 3, 4. So in that event, whether it is necessary to make them parties or not.
My lord, sir,
taking into account secure. If we ultimately accept your
then the question of seniority will come. If I claim seniority and I have not made them parties, then that may affect me.
No, obviously, once we say that you are entitled to, and they will place you on the basis of the marks, not that whatever total marks, this placement which has been made in this SC category, 1, 2, 3,
if
any, must have been based on the marks secure, total marks secure.
On the basis of the selection they made, my lord.
Right. So, so suppose there is any selection at all, and they are included, and we allow your prayer, and you have not made them party, and on the basis of a remark, you are supposed to go to the top. Then whether those 1, 2, 3 will not be affected.
That was not in my prayer, my lord, in the writ application. My lord may have looked my prayer.
Ultimately, it is likely to happen that once we
I may, that is a hypothetical. I may not claim seniority, my lord. I may be happy with the my appointment. In the event I will claim that will not be in this writ application.
Everything goes on that whether the seats have been filled up or at all or not.
Exactly. If there is a vacancy, since your lordships are protected.
Right, that is right.
Giving a direct judgment that it cannot be filled up without the leave of the court. I may be satisfied with that, my lord. My lord, what was my prayer? Can I have a look to my prayer, my lord, for a moment? My writ applications, I I prayed, I made an amendment, and amendment was allowed. And after the amendment, the consolidated writ application was filed. And the prayer in the consolidated writ application was, that was the last prayer of the petitioner. Your Lordship can get it at page 48.
48.
My prayer of the writ application, my Lordship kindly get it.
Prayer in the writ petition, that is consolidated. If we can go, then that comes in page number 35.
Yes, my Lord.
Internal page is 19 of that writ petition, and running page is 35 of your writ appeal.
Yes, ma'am. This is this prayer in the writ appeal, my Lord. As your Lordship have put me question that whether a necessary, whether those who have been promoted, that will be dependent on the writ prayer made in the writ application. I am placing, my Lord, the prayer I made in my writ application.
Yes.
At page 35. Under the above circumstances, the man issue rate, etc., any other directing opposite parties to produce the relevant records pertaining to the selection for appointment to the post of management trainee technical made by the opposite party number 3, pursuant to the advertisement by the annexure 1. And since each post of management trainees is still available to be filled up, the Honorable Court be pleased to direct the opposite parties to issue appointment order to the petitioner since injustice has been caused.
So sixth post is not in your category.
Not in your category. That is exactly what I have. You have just said that it is management trainees as well.
Yes, management trainee, my lords.
But it not stated that it is in your category.
My lords can have a look to that writ application. I have given a list of the posts that has been filled up and what is the vacancy they have made it. My category is electrical.
They filed counter in the writ.
Yes, ma'am. They filed a counter in the writ.
And accept 2.
When that first order was passed in the
case, interim order
in the writ petition.
Interim order, my lord.
Yes.
Yes. That was there, my lord, on May 3rd, 2013.
What is the exact order? Please read it out just if you have got the copy. Because the order might be reading like that if any post is lying back and like in that way usually the orders are.
Sir, good to meet sir.
Order dated?
Order dated 13th of May 2000. I'm sorry. Order dated 3rd May 2013.
WBC order.
Okay.
If any post of management training technical under opposite party number 2 meant for the scheduled caste candidate is vacant, one of such posts shall not be filled up without leave of the court.
So it is question of if and what. So that is exactly because the other side is not appearing. We are in a dilemma at that time of passing of that order.
Manos, I am in a different
because the order is very clear.
Yes, ma'am.
If any post is lying vacant, then that will be kept back. So it is the best person to answer is the company.
Yes, ma'am.
They are
company. Why my writ petition was disposed of? What is the reason? Reason is I am not made a party.
1 minute is.
My lord, the intellectual company, my lord, nowadays in July 2022, my lord, the Tata Steel has taken over the company. So the advocate particularly.
No, it is taken over by Tata.
Because the company is closed now, it has been taken over by the Tata Steel company. So phase notice should be given to the Tata Steel company.
How could they be?
Provided.
How could they be?
Added to because
But
the address and
I cannot. In that case, that if I make an amendment, they will say that you have never parties before the honorable court. Because that's a transfer, not taken over. Not abolish, transfer. Transfer it is under the yes, not Companies Act, the Reforms Commission. So that was an yes, but agreement between the Tata and this, and before the regulatory commission.
So what have they done in their MOU?
That is most relevant. Suppose they
So for the
accepted that whatever dispute is pending or whatever, they are ready to. So that must be an MOU.
Because we will be exercising all the thing, and at the end of the day, nothing will
because
come out.
my information is because that is a settlement before the Reforms Commission, Election Reforms Commission. They have taken along with assets and liabilities.
That is all right, but what about the staff?
Once asset liabilities minus generally, ordinarily, because I have not gone through their settlement, I'm to in that event. I will take assistance from your friend.
No, otherwise it would be just an order, but the other party who is now to execute it, he will not be a party before us. So that may create some problem. He has rightly pointed out now. Suppose it has been that Tata has now, it is more.
But what I have a feeling what's minor. This was made sufficient. Notice what prevented them.
No, it's all right. But at this stage, suppose an order is passed and he is directed to be.
I understand
where he will go.
Minor, I understand the predicament, but the question is, what prevented them to say that we are no longer continuing? This has gone to Tata's or Bata's. I do not.
Learned Council was appearing in that writ petition, which was disposed of by the learned single judge. That is in January 2019. 2019. It was disposed of.
Minor, thereafter notice was made sufficient. They were there by the time notice was made. If the notice was made sufficient, they could have come and say.
No, all right. Let us see the position that they are not appearing, and an order is passed. Is the Tata obligatory on the part of Tata to take it?
That's a question that unless liabilities and etc. that to be owned by them.
And more particularly with respect to the technical staff, they may not, they might not have. All these things are there. So rather, it is on you, more on you to ensure.
It would be better if you just take instruction.
Yes, ma'am.
And if necessary, make the amendment so that
by imprinting them as
right. That is
otherwise infructuous.
Written. Right. Because in the meantime, all these things, if he says so, then it has taken in
July 2022.
Yes.
So it is what is that? Tata Steel. Tata Steel.
Tata Steel.
Long Product Limited. Tata Steel Long Product Limited. It is Tata Steel Long Products Limited.
Tata Steel
Long LONG Products Limited.
Product.
Right.
My lord, with for better, your lordship may keep it.
We are not mentioning anything.
This mobile information cannot be accepted.
We are not mentioning anything. We are just, you tell us a date so that.
Minus 15 days minimum.
Okay. So let it come on week commencing from 17th of September.
Yes, sir.
Take the instruction.
I'll know the status, etc. So that it will be easy for me to, if required, I will have to amend it.
Right.
By making them parties.
Right.
It's a difficult situation.
Yes, ultimately, if we are that if we fail.
Yes, I understand. If ultimately I succeed and your lordship passes an order that there is no need of that order.
Is exactly what we want. The
simply will adjourn.
6 for an adjournment for 2 weeks to obtain certain material instruction put up this matter in the week commencing from 17th September 2024.
Sir, Shaitan observation there is because of the state has said so. I'm to get
because state that you don't mention, otherwise you would have mentioned. We just said that we should not rely on the mobile information.
No, had it.
We just said that material instruction. It may be some several kind of material instruction, including your Of course.
Material information, sir, not instructions.
Information, all right.
So,
Material information.
had it been BNSS, probably we could have taken the WhatsApp. Because we are not in BNSS, we can't.
Yes, sir.
Material information.
He's not specific because this word he.
No, it's sometimes nowadays it is so many things are coming in.
Yes, madam. Every day we are
it is
getting
very difficult to actually rely which is the correct.
Yes, madam.
So reporting is totally.
After his information, that has become a peculiar situation.
Think of the matter after which.
Pardon, Lordship. I have filed an IA for bail. The petitioner is in jail custody since 9 years. He was
Password.
Weekly list passover item number 11. Item 13.
Item.
Item 19.
I prepare an adjournment.
Next week.
Population.
Item 40.
Item 40.
ଏଟା ଶୁଣାଣି କଣ ହେଇଥିଲା
କିଛି ଆରମ୍ଭ ହେଇଥିଲା
ଅଳ୍ପ ଆରମ୍ଭ ହେଇଥିଲା ଅନସାଉଣ୍ଡ ମାଇଣ୍ଡ ଉପରେ
ଓହୋ
ଯୋଉ ଅର୍ଡର ସିଟ୍ ଗୁଡାକ ଯୋଉ ଦିଆ ହେଇଥିଲା
ଟିକେ ପ୍ଲେସ୍ କରିଦିଅନ୍ତୁ ଏଫଆଇଆର ଟା ଜଷ୍ଟ ରିକ୍ୟାପଚୁଲେଟ୍ ପାଇଁ ତାପରେ page 44
that is written by PW6 ମତେ ଲେଖି ଜଣାଇବାର କାରଣ ଏହିକି ଯେ ମୁଁ ବୟସ 45 ବର୍ଷ ଗ୍ରାମ ସାପକଛାର ଥାନା ଲେଖରିପଡ଼ା ଜିଲ୍ଲା ସୁନ୍ଦରଗଡ଼ ବୟସ 45 ବର୍ଷ ସ୍ଥାୟୀ ବାସିନ୍ଦା ଅଟେ ମୋର ବାପା ଅର୍ଜୁନ ପ୍ରଧାନଙ୍କର 3 ଭାଇ ଯଥା ସ୍ୱର୍ଗତ ଜୟଦେବ ପ୍ରଧାନ ସହଦେବ ପ୍ରଧାନ ଏବଂ ସୁଖଦେବ ପ୍ରଧାନ ଅଟୁ ସ୍ୱର୍ଗତ ଜୟଦେବ ପ୍ରଧାନଙ୍କର ଗୋଟିଏ ବିବାହିତ ଝିଅ ଏବଂ 2 ଜଣ ଅବିବାହିତ ପୁଅ ମଧ୍ୟରୁ 2 ଅବିବାହିତ ପୁଅ ଯଥା ପଦ୍ମଲୋଚନ ପ୍ରଧାନ ବୟସ 25
Padmalochan Pradhan is the appellant in this. Yes.
ଏବଂ ଅଭି ପ୍ରଧାନ ବୟସ 21 ବର୍ଷ ସେ ଦୁହେଁ ତାଙ୍କ ମା ପ୍ରଭାତୀ ପ୍ରଧାନଙ୍କ ସାଙ୍ଗରେ ସମସ୍ତେ ମିଶି ତାଙ୍କ ଅଜା ଅର୍ଜୁନ ପ୍ରଧାନ ବୟସ 65 ବର୍ଷ ଏବଂ ଆଈ ଫୁଲ ପ୍ରଧାନ 63
So
ବର୍ଷ
how then this appellant and the deceased are related to each other?
This person are Oja and I.
ଅଜା
Deceased.
Is it a case of double murder?
Yes.
Oh, I see. So, no, Ajay je, mane Padmalochan no kaun hai? Appellant ro Ajay.
Paternal grandfather and
grandfather grandmother
paternal grandfather
maternal
Maternal.
maternal
paternal
Paternal.
paternal
Okay. बट ये लाइन टा जो अच्छी पद्मलोचन विभिन्न समस्या को नहीं अजा आ वाइफ होची माने पद्मलोचन अजा ये तो मैटरनल ग्रांट
My lord, left pora support side ro jaye ko.
नहीं अजा हाँ दे एड्रेस है अजा
पैटर्नल को अजाय
हाँ नहीं इट इज अजा
ओके ठीक है
पद्मलोचन विभिन्न सामान्य घरोई कथा को नहीं तार अजा अर्जुन प्रधान एवं आई फुल सांगरे झगड़ा करथाय आज ता 2/4/2016 रे सकाळ समय प्राय 6 घंटा समय मु आज 2/4/2016 रे सकाळ समय प्राय 6 घंटा समय मु मोर घर सामने आम ग्रामर गिरिधारी क्षत्रिया सहित ठिया होइतिबा समय मोर दौड़िकी आसी आम सामने कहला जे पद्मलोचन एक काठर गेड़ारे अजा अर्जुन को तार घर बारिपटे मुंडरे बारंबार प्रहार करिबारु से तले रक्ताक्त अवस्था पड़ी अछि एवं तार आई फूल को घटनास्थल रे सही गेड़ारे गोड़रे एवं शरीर रे मारुअछि एहा शुणी हल्ला करिबारु मु तथा आम ग्रामर कपिल माझी एवं मोर स्त्री कमला आम बाड़ीपटे पहुंची देखिलु जे पद्म मोर मां को काठ गेड़ारे मारी आहत करिअछि एवं पद्म तार अजा अर्जुन को सही काठ गेड़ारे बारंबार प्रहार मारिबा फल अवस्था अर्जुनर मृतदेह घटनास्थल रे पड़िअछि मु एवं कपिल माझी पद्म को काहीकि मारिलु बोली पचारिबारु से पद्म गेड़ारे तार अजा अर्जुन को जीवन रु मारी हत्या करिछि एवं आई फूल को गेड़ारे सही गेड़ारे पिटी पिटी आहत करिछि बोली सही गेड़ारे पिटी पिटी आहत करिछि बोली आम्भଙ୍କୁ पद्म कहला मु उक्त घटना को मोर स्त्री कमला स्वचक्षु रे देखिछि मोर मां पद्मर माड़रे आहत होइतिबारु ताकू सुंदरगढ़ सरकारी डाक्तरखाना को चिकित्सा पई पठाई अछु एणु सविनय अनुरोध करे कि मोर बापा अर्जुन प्रधान को जीवन रु मारी मोर मां फूलों को मारी आहत करथिबा हत्याकारी पद्मलोचन प्रधान को विरुद्ध रे हत्या मामला रुजु करी दृढ़ कार्यानुष्ठान निया जाऊ
जो कमला सोचक्षु रे देखछि माने कमला इज पीडब्ल्यू
कम PW2 PW सर
PW
15 से कौन
फिर हम प्रधान 15 16
बुझली गलनी
कमला प्रधान इज it says 83 PW16
PW16 लिखा है
PW16
so on the last date you said that there are 3 eyewitnesses to the occurrence
yes.
One is PW2 the other is PW15 and 16 right
yes my lord
and there are 2 deceased one is Arjun Pradhan the other is Pulamati
Pradhan
and 2 doctors also conducted postmortem examination.
Yes,
one is PW12
at 20
who conducted Arjun and PW20 who conducted PM of Pulamati, right?
Yes.
So let us just see that eyewitness PW2 statement
at page 57. Examination in chief. The informant is my father. The accused standing in the dock is my elder brother, being the son of my elder father. The deceased persons are my paternal grandparents. The occurrence took place prior to 7 years back, one day at about 6:30 a.m. at the backside of the house of the Sahadev Pradhan. My parents' house is at village Sippokochur. At the relevant time, I had been to the backside of my firewoods. At that time, I saw the accused standing in the backside of the house by holding a wooden plank. Nearby him, my grandfather Arjun was lying on the ground, sustaining bleeding injuries on his forehead. I immediately rushed to my house to report the matter to my father. I again come to the spot with my parents and found my grandmother Pulamati lying near my grandfather, sustaining injuries. While we were moving towards the spot, I saw the accused was holding
leg of my grandmother and rotating. My father called the villagers and they also saw the injured person at the spot. Cross-examination.
In fact, he has not seen the actual. She had not seen the actual
Assault he has not seen.
Her presence is there at the the accused was appellant was present when the dead bodies were lying, and she was also armed with a wooden plank. And then again she was rotating that
Leg.
The leg of
the grandmother. Yes. Then
PW 15 will.
PW 15 or PW 6.
PW 15, it is page 80.
Okay. Yes.
I know the informant who is my brother-in-law. Who is my brother-in-law. I know the deceased persons who are my in-laws. I know the accused standing in the dock who is my son. The occurrence took place 6 years back, one day at about 6 a.m. in the burial land of the house of the deceased.
This lady is the mother of the
Mother.
Yes, ma'am. At that time, my parent-in-laws, myself, my two sons, including the accused, the informant, and his wife Kamala, were staying in the house of the deceased. At that time, I, along with my mother-in-law Phulmati, were cleaning the utensils. At that time, the accused came to the spot and dealt a first blow on my head. Fist blow, sorry. By which I fell down on the ground. I lost my sense. After regaining from sense, I found the accused by holding the hands of Phulmati, thrust her on floor. Out of fear, I fled away inside and called the villagers to hold the accused. When I returned, I found the accused had already assaulted my father-in-law as well as mother-in-law. I found my father-in-law died at the spot, and one of the eyeball had come out from the eye. My mother-in-law was struggling with her life, and she was shifted to Sundargarh Hospital. When I come back from the village, the informant Kamala, my son Abhiram, were present at the spot. One Sulochana Pradhan also come to the spot. Subsequently, the accused assaulted my in-laws by means of a sal lathi. During treatment, my mother-in-law died at the hospital. 3. Prior to the occurrence, the accused used to make quarrel with me as he was suffering from mental disorder. Once the accused had assaulted me, for which I left for my matrimonial house at Ratanpur. Cross-examination. It is a fact that the accused was suffering from mental disorder, for which we had taken him to Burla Hospital, and he was there for a month as indoor patient. And we also frequently brought him to Sundargarh Hospital for treatment of his mental illness. The accused was given medicines for his mental illness by the doctor, but the doctor had never told us that my son is a psychiatric patient. The mental disorder of the accused started when he was reading in class 8. After taking medicine, the accused again behaves normally. It is a fact that when his mental disorder starts, he does not understand the work which he does. 5. Except thrashing my mother-in-law by the accused, I had not seen assault on my in-laws, as I pledged to call the villagers. It is a fact that after calling the villagers, I had not entered into the house. I had not seen whether Kamala was present in the house at the time of occurrence, but she told me that she had been to school at that time.
Kamala means PW 16.
PW 16. It is a fact that Abhi was sleeping inside the house at the time of occurrence. I was not examined by police. This is for the first time I am deposing about the case. I cannot say whether the accused had committed murder of my parent-in-laws. The lathi was about 2 to 3 feet length. It is not a fact that there was no such occurrence, and I am PW6.
So far as this particular witness is concerned,
yes,
she has stated about the assault by the appellant to that lady, Phulmati, na? Because by the time she came again, the assault was already over on both these. And
Actually, she was assaulted.
Right. She was given a fish blow on the head. And then when he regained sense, found that the okay. So, but one thing is that he has not stated that any weapon he was holding. He stated that only holding
Wooden
the
plank.
hands of so and so and faster, which is of course deposed to by PW2 that he was holding some
Plank.
wooden plank.
उन्हें से जो senseless allowly कुछ that is for a just she got blackout.
Yes. उठिला बेलको already. Yes. Then PW16.
At page 83. Examination in chief. I know the informant who is my husband. I know the deceased persons who are my in-laws. I know the accused standing in the dock who is my nephew. The occurrence took place 6 years back, one day at about 6 a.m. in the body land of the house of the deceased. At that time, my parent-in-laws, myself, my husband Prabhati and her 2 sons, including the accused, were staying in the house of the deceased. At that time, I had been to school. After getting information at school and heard that the accused had assaulted my parent-in-laws by a lathi. Due to assault, my father-in-law died at the spot. I, along with others, shifted my mother-in-law to Sundargarh Hospital.
So he heard.
He is not a eyewitness. He submitted the other day. Acha, he was declared hostile.
Hostile.
Acha. Okay.
Again, re-examination is there, and she is
yes.
saying that it is a fact.
It's a fact that I've stated like this.
Yes.
So all she has agreed it's a fact. Not to level.
Yes.
Madam.
Mental problem katha asila paragraph 3 of cross examination.
Yes, madam.
When his mental problem arises, he used to act differently, but he does not suffer from the said problem. When
he does not suffer from the said problem, he behaves normally.
No scarf of a paper in that figure. So, only oral submission. No, that is how the court has expressed its opinion.
Yes.
That the accused is not a lunatic. He is able to understand the thing and can rationally answer also. Achha. So, have you gone through that?
Yes.
Order sheets? Because for quite long, the court has taken all possible steps as is required under the provisions of CrPC.
Yes,
तो आपण otherwise ये जो अच्छा what about the PM report?
PM both. PW12.
हाँ गोटे PW12.
12, yes. At page 74. Last rated. That's the Arjun.
ये काम कर रही थी अर्जुन आचार्य.
Yes. Fracture of underlying skull, frontal bone, exposure of brain matter. Exposure of brain matter थियो कहीं ना सिर्फ गोटे high voltage variation. Depressed wound with lacerated. So जो गेडर है तो बड़ी ची मुंडो को. Right eye with shrunken eye, eyeball inside orbital cavity with fracture of orbital bones. The bank moved to the thrust extended to left forehead obliquely to 4 inch, 1 inch with fracture of underlying nasal breeze with brain matter through it. Mundaru eye covering.
Death was due to shock as a result of vital organ like brain and multiple fractures of bone. And wooden plank जाइथला wooden plank को देखो opinion
is there, yes.
Opinion decision be possible very. How से जो आरटा लेडीटर
of PW20.
At page 91.
External injury la nasal breeze, right side eye,
Bony
Then a spinal cord and normal having the other cause of pain. And the বেশি serious নাই কিন্তু
মুহটা মাড় হয়েছে বলে নজল ব্রেক
salt and hemorrhage to internal injury কিছু নাই but I find the injuries found in the body can be possible by the state of unsatisfaction sufficient to
course of nature.
It says something that are found intact. Then as one of the thing normal develop. Other organs strong.
I opine the injuries found, মানে cumulative. I opine injuries found on the body of the deceased can be possible by the side of
right here. I would the right side either of the immediate from
scratches.
Fracture injury is
এই যে বনি ডেপথ দুইটা হয়েছে That is your ground.
Yes, madam.
that is so long.
That's the sole ground. সেটাতে কিছু না
And see in your accused statement you have stated nothing about
your health.
ମାନସିକ ଇଏ ଗୁଡା କିଛି ନେଇ ନା
Last line.
ମୋ ଜନ୍ମରୁ epilepsy
epileptic
epilepsy is something different ଏଇ ଯୋଉଗୁଡାକ ସବୁ ଯୋଉ ବାତ ମାରନ୍ତି that is not the something different ଦେହ ଖରାପ ହେଲେ ମୋର ହୋସ୍ ରହେନି ମେଡିସିନ ଖାଇଲେ
that means
epilepsy ଗୋଟେ ଡେଞ୍ଜରସ୍ ଥାଏ ଗୋଟେ ପଡିଯାଆନ୍ତି ମାନେ
that is
ପାଣିରେ ଗାଧୋଇ
that's a kind of at times they cannot resist those kind of situations. So some people if see the crowd they get convulsion. That is convulsion. In fact it is not senseless, they get convulsion.
Bathroom re mone karo iye la mana pisam for automatic it depends upon who type
character but it cannot be
epilepsy
is not on soundness. But my lord, the case record that is undated 23/5/22. Order sheet. Yes, my order sheet. That is 23/5/22.
The case record is put up.
The UTP is violent and the jail superintendent seeks permission to shift the UTP to Bhimsar Burla for
ସେଇଟା ତ ଆମେ ଦେଲୁ ସେଇଥିପାଇଁ ତ ପଚାରିଲୁ ତାପରେ କୋର୍ଟ ନିଜେ ହୃଦବୋଧ କଲେ ଯେ ୟାକୁ ଦରକାର ବୋଲିକିରି ତାପରେ ତାକୁ ପଠେଇଲେ ତାପରେ କଣ ହେଲା what is his final outcome that is 22/6/22 final outcome is 22/6/22 he was sent because court it is not this order that the court has several order has been passed by the court but this is the final opinion because otherwise he could not have proceeded further without recording a finding that he is fit and rationally to answer.
And in fact, in a case of this nature, the relevant date is the date of occurrence. Suppose in 22 ମସିହାରେ ଆପଣଙ୍କର କଣ ହେଲା, that is no relevant. So at the time of occurrence, you must be, that is the position of law, and that is
the position
time of doing it. So that is most important. At the time of doing it, by reason of unsoundness mind, is incapable of doing it.
And to that effect, if you say you have brought one question that he was suffering since class 8,
yes,
if that is so, the nature of sufferance is not.
The peculiarity of this case is that the prosecution witness are at the same time they are the defense witness. They are the they are his own relatives, own family member.
Obvious that kiye achandi, kiye
defense witness kehi nahanti.
Defense witness ko.
My lord, they are if that they are the prosecution witness.
No, they have given some statements
yes,
in the cross-examination, which to some extent
shows that
the accused was not in a proper mental condition.
Yes, ma'am.
But again, madam, the relevant as this
I may be wrong.
of this court, the Honorable Supreme Court, and the section more particularly.
Yes, ma'am.
You have to bring some material on record. ଆପଣ ପାଖରେ ଯାହା ମିଷ୍ଟର ତ୍ରିପାଠୀ ପଏଣ୍ଟ ଆଉଟ୍ କଲେ, ଯଦି ଆପଣ କୌଣସି ମେଡିକାଲ ଡକ୍ୟୁମେଣ୍ଟ ଦଉନାହାନ୍ତି, ତେଣୁ ଓରାଲ ଏଭିଡେନ୍ସ ରେ ଆପଣ କଣ ଆଣିଛନ୍ତି ଯେ ଯେଉଁଥିରୁ ଆମେ ଉଦ୍ବୋଧ ହବୁ ଯେ ଯୋଉ ସମୟରେ କ୍ରାଇମ ଟା କଲା ସେ ସମୟରେ ତାର ମାନସିକ ଅବସ୍ଥା ଏମିତି ଥିଲା ଯେ ସେ ଜାଣି ପାରୁନଥିଲା କଣ ସେ କରୁଛି, whether it was right or wrong.
And there is nothing about the past conduct also.
Except
yes
question.
କାରଣ ସେ ଯୋଉ ଅଷ୍ଟମ ଶ୍ରେଣୀରେ କଣ ହେଇଥିଲା ବୋଲି ଯିଏ କହୁଛି
whether he was violent or କିଛି ନାହିଁ, nothing is there.
ଖାଲି ଗୋଟେ ଜିନିଷ ଆସୁଛି ଆପଣଙ୍କର ସେ ଯୋଉ ଘଟଣା ପରେ ଗୋଡଟାକୁ ଧରିକିନି ବୁଲଉଥିଲା ଏବଂ ସିଏ ସେ ଜାଗାରୁ ପଳେଇ ଯାଇ ନଥିଲା, ସେଟା ସେ ଦିଟା ଜିନିଷ ଯୋଉଟା ଅର୍ଡିନାରଲି ଏକ୍ସପେକ୍ଟେଡ ଯଦି କନସିୟସ୍ ଥାନ୍ତା ବା ଇଏ ଥାନ୍ତା ସେ ପଳେଇ ଥାନ୍ତା, କିନ୍ତୁ ଇଏ
informants in his deposition states that he called him and he come and sit in the veranda.
He came and sat on the veranda.
But it ଆମେ ଗୋଟେ straight jacket formula କହିହବନି, ଗୋଟେ ଲୋକର ଗୋଟେ accused ର ଯେ particularly ଏଇ type ର reaction ହବ ସବୁବେଳେ assault କଲା ପରେ ଗୋଟେ accused ଏଇ type ର reaction କରିବ. It is not, there is no straight jacket formula. ଗୋଟେ accused ମାରିଦେଲା ପରେ ପଳେଇବ ନିଜକୁ ସେଭ୍ କରିବା ପାଇଁ ବା ଇଏ କରିବା ପାଇଁ, ସେମିତି ତ କହିହବନି. ୱିଟନେସଙ୍କର ରିଆକ୍ସନ ଯେମିତି ମାନେ ପ୍ଲେସ୍ ଅଫ୍ ଅକରେନ୍ସ ବିଭିନ୍ନ ପ୍ରକାର ହେଇପାରେ. ସେ ମାଡ ଦେଖୁଛନ୍ତି, କିଏ ହୁଏତ ଯାଇକିନି ରେସ୍କ୍ୟୁ କରିବାକୁ ପହଞ୍ଚିବ, କିଏ ହୁଏତ ଆକ୍ୟୁଜ୍ଡ କୁ ପ୍ରୋଟେଷ୍ଟ କରିବ, ହେଲା, କିଏ ହୁଏତ ନିଜ ଘରକୁ ପଳେଇବ, କାଳେ ତା ଉପରେ କଣ ହବ, କିଏ ହୁଏତ ପାର୍ଟି କରିବ, ତ ବିଭିନ୍ନ ପ୍ରକାର ରିଆକ୍ସନ ହବ. କିଏ ଚୁପ୍ ରହିଯିବ, ମୁଁ କାହିଁ ଯିବି, ମତେ ପୋଲିସ ଡାକିବ ସାକ୍ଷୀ ଦେବା ପାଇଁ. So that is how the reaction of it. So also the accused may vary. So merely because the accused did not ran away from the spot after committing the crime in question, can it be said from that conduct that the accused was of unsoundness of mind at that point of time?
And it cannot also outweigh the opinion found by the court, which could have been challenged. Court has formed an opinion finally in accordance with law under section 329 CrPC.
The final realization this. It is 28. That is order dated 17/7/2023. My lord, the order is dated 17/7/2000.
77, but again, as Mr. Tripathi is saying, no documentary, no paper is there. The learned counsel, defense counsel is saying, the learned counsel, by referring to the report submitted by the director of Mental Health Institute, Cuttack, contended that the doctor has opined that there was occasional symptoms of psychiatric disorder of the accused. The learned counsel contended that it is all along the plea of the accused that he was suffering from mental disorder, and at the time of occurrence, he was suffering from the said disorder. But it must be backed by some document, no? Where is that MHI report? সেটা ନାହିଁ, submission ଖାଲି।
ମନେକର ଆପଣ ଔଷଧ ଖାଉଥିଲେ କୌଣସି ସାଇକିଆଟ୍ରିକ ପ୍ରୋବ୍ଲେମ ପାଇଁ ବା ମେଣ୍ଟାଲ ପ୍ରୋବ୍ଲେମ ପାଇଁ, ତ ଡକୁମେଣ୍ଟାରୀ ଏଭିଡେନ୍ସ ଆସି ପାରିଥାନ୍ତା, ପ୍ରେସକ୍ରିପସନ କି ସେ ଡାକ୍ତର ଯୋଉ ଯାହା ଖାଉଥିଲେ ତାକୁ ଆଣିକିନି ଡିଫେନ୍ସରେ ଦେଇ, ଆପଣଙ୍କର ଷ୍ଟାଣ୍ଡଟା ଯଦି ସେଇଆ ହଉଛି।
They said that treated homely treatment.
No, we cannot go beyond that. No. See, again, you come down to that paragraph. What is required under law has to be recognized. So, as per the direction, accordingly, as per the order dated 12/4/23, this court issued a letter to the CDMO Sundargarh to form a board and to submit a report regarding mental disorder of the accused. After forming a board, the CDMO Sundargarh submitted the report of the said board mentioning any perpetual abnormality with the accused, but for the second opinion, the board requested to send the matter to Vimsar Burla, and Vimsar Burla also submitted a form board to submit the report, but subsequently Vimsar Burla by later such and such denied to form a board as there was a vacancy in the post of Professor Psychiatric Department. Vimsar Burla also made a request to the court to refer MHI Cuttack. MHI Cuttack report କାଣ ସେଇଟା
According to further
আসছে report আসছে। Accordingly, by order dated 7/6/23, this court issued a letter for examination of the accused by MHI. Cuttack को ଆସିଥିଲା ସେ report submitted by MHI. Cuttack does not disclose a mental disorder for a continuous period with the accused, which resulted in presumption that because of his mental abnormality, the accused was unable to know the consequences of his act. Furthermore, the report of the MHI Cuttack does not reveal that the accused was suffering from mental disorder at the time of occurrence. That is what I said.
এই যে টাইম অফ ডুইং ଯୋଉଟା ୱାର୍ଡଟା ରହିଛି, Honorable Supreme Courtର decisions ହଉଛି to establish a defense on the ground of insanity. It must be clearly proved that at the time of committing the act, the accused was laboring under such a defect of reason from disease of mind as not to know the nature and quality of the act as he was doing, or if he did not know it, that he did not know he was doing what was wrong or contrary to law. The crucial point of time at which unsoundness of mind should be established is the time when the crime is actually committed. The mere fact, this is most important, the mere fact that on former occasion, the accused had been occasionally subject to insane delusions or had suffered from derangement of the mind, or that subsequently he had at times behaved like a mentally deficient person, see insufficient to bring his case within the exemption. So, in order to ascertain whether the accused was insane at the time of commission of the offense, it may be relevant to consider the state of such person's mind immediately preceding as well as subsequent to the commission of the offense. This is the law laid down by the Honorable Supreme Court. ତେଣୁ ଆପଣ ଏଠି documentary evidence nil, evidence of the doctors ଯୋଉ ପଏଣ୍ଟରେ ଜିନିଷ ଆସିଲା ସେମାନେ ବି ଦେଲେ ମନା କଲେ। ତେଣୁ ଆପଣଙ୍କର at the point of time ବା ଯେତେବେଳେ ହେଲା ତା ଆମେ ଯଦି କିଛି ନାହିଁ ତାର ପୂର୍ବ କଣ୍ଡକ୍ଟ ଏବଂ ତାର ପର କଣ୍ଡକ୍ଟକୁ ଯଦି ବି ଦେଖାଯିବ ତାହେଲେ ତା ପୂର୍ବ କଣ୍ଡକ୍ଟରେ ତ ସେମିତି କିଛି ନାହିଁ, पर कंडक्ट रे आसी आपण से जागारू पळै जाई नांती सेठी बसिथिले आउ से जो आपणकर आई रो गोड़ को धरी बुलौथिले दिस इज द ओनली मटेरियल आउ बाकी कंसिस्टेंट केस तीन जन साक्षी आई विटनेस अफसो गोटे साक्षी देखिनी पूरा बट योर upon presence with the weapon of offense at that place,
a circumstance,
and circumstance that is a very clinching circumstance, apart from the अन्य मानक statement जोड़ा, आउ जो type रो injury ही ची, से जो male person को जोड़ा को अज्ञा कहउछंती, तो सब गुड़ा को injury ही जैसे wooden plank रे assault रहले से injury ही परियो बोली doctor भी कहउछंती.
The wooden plank is also.
No, if you have brought any decision, you can cite. There is no. This is the law, I think.
I had cited some decisions, but
and anything if you have brought out in on record through other evidence, we just saw the evidence of 3 eyewitnesses, 2 doctors. These are the things. If any other witness has stated anything, so far as the mental aspect is concerned.
Yes, my lord. Other witnesses are also speaking.
कौन कहउछंती?
All right. I am going one by one. PW3 at
आपनको mental ये विषय किए कहउछंती पर
PW3
just a minute. Mental element PW3
at
we'll
page
take
60.
note of it, then we'll go one by one. PW3 two paragraph
at page 60 cross examination.
Page 60
Page 60 paragraph 4 cross examination.
all right sir कही जाते तापर आपको witness
PW4 at page 62 paragraph 4
page
62
page 62
at paragraph 4.
Paragraph 4. Yes, then
the informant that is PW6 at page 66 para 4. Thereafter PW7 at page 67 paragraph 3.
page 67 paragraph 3. Yes.
Thereafter PW13 at page 78 paragraph 3. Thereafter PW15 at page 81 paragraph 3 paragraph 4. 16 at page 84 paragraph 3. PW17 as per at page 88, that is paragraph 3. This much.
So you start from the backside.
Yes,
PW17 को पढ़े आसो.
PW17.
77 आपण PW17 आपण कहले page 88. Let us see what he has stated.
Examination in chief.
Paragraph number. You said paragraph 3.
I had not.
Is 70.
Directly you come to that.
Yes,
it is a fact that.
I had not seen the occurrence. I cannot say who assaulted my grandparents.
No, आपण केवल.
It is a fact that my brother.
Yes.
Say the third line.
Third line.
It is a fact.
Yeah.
Third line.
Third line. I had not assaulted. It is a fact that my brother is suffering from mental disorder and also taking medicines regularly. It is a fact that when the accused does not suffer from mental illness, he behaves properly. But in case of disorder, he becomes violent. It is not a fact that there was no such occurrence and I am deposing falsehood.
Then you come to PW16, page 84. Backside one asked you.
Yes, madam. It is a fact that the accused is suffering from mental disorder When his mental problem arises, he used to act differently. When he does not suffer from the said problem, he behaves normally.
Okay, then you said PW 1581.
81. At paragraph 3, prior to the occurrence, the accused used to make quarrel with me as he was suffering from mental disorder.
Okay.
Once the accused assaulted me.
No, you read that cross-examination.
Yes, madam. It is a fact that the accused was suffering from mental disorder, for which we had taken him to Burla Hospital and he was treated there for a month as an indoor patient.
We also, again.
Yes, ma'am.
And we also frequently brought him
into Sundargarh Hospital for treatment of his mental illness. The accused was given medicines for his mental illness by the doctor, but the doctor had never told us that my son is a psychiatric patient. The mental disorder of the accused started when he was reading in class 8. After taking medicines, the accused again behaves normally. It is a fact that when his mental disorder starts, he does not understand the work which he does.
Then out of PW 13 13 page 78.
78. It is a fact that the accused is suffering from mental disorder and it was prior to the date of occurrence. It is a fact that the accused was undergoing treatment for his mental disability and my parents were looking after his treatment. My parents have affection for the accused and kept him with them. I was not examined by police.
PW 7, that is page number 67.
Yes, madam. I had seen the occurrence. My house is at a distance of 2 kilometers from the informant. The accused is suffering from mental disorder.
Then PW 4, paragraph 4.
The accused is suffering from fits, epilepsy.
Mental disorder. Then PW 3.
Sorry,
paragraph page 60.
Page 60. I'm sorry, my lord. I read it earlier. The accused is suffering. The accused is suffering from fits, epilepsy, and the accused is suffering from mental disorder because of this said disease. It would be a discrepancy. I had not seen the occurrence, I had only heard about it.
Six and 5 both have stated about fits, epilepsy. And from the tenor of the statement of all the witnesses, even if it is admitted by all of them, so it is at the time when the disorder occurs. Obviously, when the epileptic attack is there, he doesn't understand. And it is an attack. ତେଣୁ ସମସ୍ତେ କହୁଛନ୍ତି ତା ଦେହ ଖରାପ ଅଛି ମେଡିସିନ ଖାଇଲେ ଠିକ ହୁଏ ମେଡିସିନ ବି ଖାଉଥିଲା so epileptic is there.
The condition of epilepsy is neither an incurable disease nor can it be considered a mental disorder or a psychopathic disorder for making the ground. Epilepsy. Decision এটা ঠিক লিখুন, এটা সুপ্রিম কোর্ট ডিসিশন, এটা কেরালা সিঙ্গেল জজমেন্টস আছে সাইড করতে কন্ডিশন the light of this one so that it's କେତେ ପେଜ ର ଏଇଟା ଏଟା ଟୋଟାଲ ତାର ଗୋଟେ ପ୍ରିଣ୍ଟ ଆଉଟ୍ ବାହାର କଲେ ବେଶୀ ପେଜ କି 20ଟା ପେଜ ବାହାର କଲେ ପ୍ରିଣ୍ଟ ଆଉଟ୍ ଟା ଦେଖିଆ ସିଙ୍ଗଲ କପି ବାହାର କରିଦିଅ both side ଯଦି offer ନହେଲେ single side ଯାହା କର single copy ବାହାର କଲ 20 ଶାନ୍ତି ପଢୁଛି ଏଥିରେ
schizophrenia अच्छी consistent report of schizophrenia.
Yes, paragraph. Like government doctor
Yes.
ट्रीटमेंट
बस बस
छोड़ा से डिफेंस विटनेस थोड़ा एग्जामिन
ये सब गुड़ा एविडेंस अच्छी all are supported by evidence. इतने डॉक्टर किसी दिले नेगेटिव ओपिनियन
This decision which we are going through is the latest decision of the Honorable Supreme Court. That is Prakash Nai, Prakash N-A-Y-I, alias Sen. Just note down and we go through it subsequently. Prakash. Prakash.
Yes, sir.
N-A-Y-I, Nai, alias Sen, versus State of Goa. Right? And that decision was rendered on
23
12th January 2023. Justice Gawai and Justice Sandres, that is division bench decision, and that was this plea was accepted in that case. But there are so many things in that case.
And he was schizophrenia, patient of schizophrenia.
And we just searched for this medical thing that so it is said that the condition of epilepsy is neither an incurable disease nor can it be considered a mental disorder or psychopathic disorder. So that's of course a divorce case. So
this is a disease, but not mental disease.
Another thing is there are two types of insane: medical insane and legal insane.
Right. We are concerned in 84 deals with legal insane.
Legal insane is not a legal insane. Throughout the trial, the court could not find a single symptom of his.
No, even the court, of course, has taken some steps also to ascertain, because the moment it comes to the notice of the court or any petition is filed, it is the duty of the court, and the court has rightly also taken all those steps. But ultimately, the report has come and a finding has been arrived at that no, this is okay. So.
And in this case, of course, the trial court as well as the High Court had not taken those aspects which the trial court in this case has. A thorough step has been taken in 329, and the reports are there.
Any further argument you want to advance?
My lord, I have cited some judgments.
Please. Give those judgments. Just indicate the paragraph number which you think are relevant.
One.
No. Upon the judgment guda douchandi, judgment guda kare jo paragraph is unsoundness of just mention it. Paragraphs relevant. We'll verify. ଗୋଟେ set ଦିଅନ୍ତୁ ଦିଟା set ଦରକାର ନାହିଁ you give one set Mr. Tripathi anything one set or any decision you want to cite you can give it to us. So madam जो decision गुड़ा दौरान एटा लिखिदेवे appellant करो एटा ଆଉ Mr. Tripathi जोटा लिखुଛନ୍ତି ସେଟା state ର heading କରି ଗୋଟେ ଅଲଗା punch କରିଦେବେ ହେଲା Mr. Tripathi please note the paragraph now ऊपर लिख दियो सब ऊपर Bhakti Sudha sir. Learn counsel for the learn an amicus curiae. Nice sir.
Yes, madam.
Amicus curiae.
Amicus curiae.
Learn an amicus curiae.
No, legal aid na amicus curiae.
Amicus curiae.
Amicus
curiae. For the appellant and Mr. C.K. Tripathi. And additional standing for the state. The land counsel for the respective parties. Five some citations which are taken on record. Hearing is closed. Judgment is reserved. Starting for the so any other matter? 30? We'll take up tomorrow. 36 ଆପଣ କରିବେ ନା
36 ନା 33 30
ନାଇଁ ଆପଣ କି କରିବେ ଆପଣ ରେଡି
ମୁଁ କହୁଛି
ହଁ
ଏଟା ନାଇଁ ମୋର 30
ହଁ you get ready ତ ନମ୍ବର କରିଲେ ସେମାନେ ଷ୍ଟେଟ କାଉନସିଲ ରେଡି ହେବେ ନା ତ ଆପଣ ଯୋଉମାନେ ଅଛନ୍ତି କହିଦିଅନ୍ତୁ so that କାରଣ ଏଗୁଡାକ ସିରିୟଲି ଆମେ ନଉନୁ ତ ଯୋଉମାନେ ରେଡି ଅଛନ୍ତି ନଉଛୁ ତେଣୁ ଆପଣ ଆଗରୁ ଜଷ୍ଟ ଇଣ୍ଟିମେଟ କଲେ they should also prepare ତେଣୁ 30 ଆଉ 33 ଏଇ ଦିଟା କହୁଛନ୍ତି ତ ମିଷ୍ଟର ତ୍ରିପାଠୀ 30 ଆଉ 33 ପାଇଁ ଆପଣ କହିଦିଅନ୍ତୁ ରେଡି
I will do.
30 भी ready है
30 नंबर अपन यदि करिवे रेडी है
30 को दो
এই সব কালেক্ট করব ফার্স্ট আপনি লিখিবে appellant এটা